and many other sources.
For potential students to understand and respond to this continental problem, the university has established solar farms backed up with strong power systems to help students realize their skills. Trained and qualified staff are all on the standby to guide potential students.
What we'll be doing here will be different from what is practiced in other places, because here we focus on training our students not just to understand ideas related to the course, but will help them set the pace in creating solutions to renewable energy problems in their communities.
The quorum for this matter is the Honorable Mr. Justice Desmond Babatunde Edwards, Chief Justice of the Republic of Sierra Leone, the Honorable Mr. Justice Nicholas Colin Brown Mark, Justice of the Supreme Court of Sierra Leone, the Honorable Mr. Justice M.F. Din Tarawale, Justice of the Supreme Court of Sierra Leone, the Honorable Mr. Justice Alosain Sani Sise, Justice of the Supreme Court of Sierra Leone, and the Honorable Mr. Justice Ansumana Ivan Sise, Justice of the Court of Appeal.
Case called. Who appears?
Presentation for the plaintiff is as on the hearing.
Thank you.
My Lords, representation for the Attorney General and Minister of Justice remains the same.
Plaintiff present. Oh, Electoral Commission.
Sorry, the second defendant is here.
Let me go. Step by step.
Observing at the hearing, we were on the right-hand side. Simply,
You are correctly placed.
I thought as much, but I had been in this court when they swapped us over, and I remonstrated. Especially in a jury trial. in which I appear, they put us far away from the jury. But it is not for us to say how it should be done. But this time we are correctly placed.
By originating notice of motion dated the 28th of November 2022, the plaintiffs instituted action in the Supreme Court entitled SC 6/2022 to invoke the original jurisdiction of the Supreme Court pursuant to sections 124 and 127 of the Constitution, Act number 6 of 1991, praying for the following reliefs. A declaration that on a proper and purposive interpretation of Section 38A of the Constitutional Amendment Act number 15 of 2001, the controlling provisions stipulated in subsection 1 thereof, namely in constituencies, is ultra vires the Constitution 1991 as amended. C, a declaration that the current Parliament was itself elected on a constituency basis as provided for in sections 38(1), 2, and 3, and that these constituencies are still extant and subsisting. D, a further declaration that revision of constituencies as provided for in section 4, subsection 4 of section 38 does not necessarily result in the establishment of constituencies stipulated in section 38, 1, 2, and 3, but that rather the section provides for the period when existing constituencies should be reviewed, which revision may or may not necessarily result in a delimitation of the respective boundaries of existing constituencies. E, a declaration that to rely on Section 38A of the 2001 Act, as stated by the second defendant in their press statement, would preclude independent candidates from contesting for Parliament as contemplated in Section 77M of the Constitution of Sierra Leone, Act number 6 of 1991. F, a declaration that the entirety of Section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local councils elections. The word basis on which local authorities were last elected is the subsisting and lawful basis on which any public elections involving local authorities can be held, and not the proportional representation system. G, an order restraining the second defendant, its agents, servants, privies, or howsoever from taking any steps aimed at conducting the June 2023 multi-tier public elections on a proportional representation basis. H, an order directing the second defendant to hold the June 2023 elections for ordinary members of Parliament on a constituency basis as presently established. I, a declaration that Section 2 of the Statutory Instrument number 83, dated 16th November 2022, making provision for both proportional representation for members of Parliament and local council elections, is ultra vires Section 33 and 38 of the Constitution 1991. The application was supported by the affidavits of Honorable Abdul Kagbo, Member of Parliament representing constituency 077 in the Potloko District in the Northwestern region of the Republic of Sierra Leone, and Councillor Hakiratu Maxwell Cocker, elected councillor for Ward 414 in constituency 118 in Freetown in the Western District. The first and second plaintiffs, respectively, both sworn to on the 28th November 2022. On the affidavit of the first plaintiff, Honorable Abdul Kagbo, was attached two exhibits, namely Exhibit AK1, which is a true copy of Clause 57 of the Public Elections Bill 2022, and Exhibit AK2, which is a letter dated 15th November 2022 from Joseph Fitzgerald Kamara Esquire of JFK and Partners, solicitors for the plaintiff's hearing, to the Secretary to the President, requesting for the Secretary to the President to furnish them with a copy of the presidential directive issued to the Chairman of the Electoral Commission to conduct the June 2023 elections on the basis of the district block representation system. On the affidavit of the second plaintiff was attached one exhibit, to wit Exhibit HMC1, which is a copy of the press statement dated 21st October 2022 from the second defendant hearing. Accompanying this originating motion, notice of motion and affidavit in support of motion, was the plaintiff's statement of case, also filed on the same date, the 28th of November 2022. The defendants had 10 days thereafter service on them of the plaintiff's papers without leave to file a statement of the defendant's case. Service of the plaintiff's papers was effected on the 30th of November 2022, and on the 8th of December 2022, both defendants obliged this Honorable Court with statements of the defendant's case. Taking cognizance of Rule 97.1 of the Supreme Court Rules Public Notice Number 1 of 1982, which states that, quote, this court may, after considering the statement of the plaintiff's case and of the defendant's case and any arguments of law, decide to determine the action and give judgment in court on a fixed date without argument. I have taken liberty to produce herein, despite their length, a verbatim production of the plaintiff's and defendant's case. Statement of the plaintiff's case pursuant to Rule 92 of the Supreme Court Rules. Facts and particulars of the plaintiff's case. The first plaintiff was elected as an MP in 2019 to represent constituency 77 in the local district in the northwestern region of the Republic of Sierra Leone. The second plaintiff was elected as councillor in the Freetown City Council in 2018 for Ward 414. The respective constituency and ward of both plaintiffs are still extant and subsisting, and they have not been delimited by revision nor disestablished by law or otherwise. In 2022, a bill entitled the Public Elections Bill was introduced in Parliament. Clause 57 of the said bill provided as follows, quote, a general election of members of Parliament other than paramount chief members of Parliament shall be by A, the one-member constituency system under subsection 2 of section 38 of the Constitution, or B, the district block representation system in accordance with section 38A of the Constitution, as set out in the 12th schedule, unquote. During the first and second readings of the bill, it was evident that there was strong and vocal opposition to the bill insofar as it purported to introduce the district block system of voting for the ordinary members of Parliament. The Speaker of Parliament, perhaps sensing the mood of Parliament, later unilaterally withdrew the said Clause 57 from further consideration by Parliament. The Speaker then pronounced from the chair that proportional representation system of election was already part of the laws of this country in light of the amendment introduced by Section 38A of the Constitutional Amendment Act number 15 of 2001. Then, on the 21st day of October 2022, the Electoral Commission for Sierra Leone issued a press statement in which it stated that on the directive of the President of Sierra Leone, it would use the district block voting system contained in the amendment to the Constitution introducing Section 38A thereof. Submissions. In the forefront of and central to the plaintiff's case is that, given the provisions of Section 38A, amending the then Section 38 of the Constitution 1991, it would be ultra-vires and unlawful to hold the June 2023 multi-tier public election for the country on proportional representation basis as stated in the Electoral Commission of Sierra Leone ECSL press statement dated 21st October 2022 for the plain and simple reason that the condition precedent to bring Section 38A into operation, namely, quote, where there are no constituencies are not present, as there are extant and subsisting constituencies provided for in Section 38(1) of the Constitution 1991 and local council wards as provided for in the Local Government Act 2004. Therefore, it is submitted for the plaintiffs that to conduct the 2023 elections on the basis of the proportional representation system would offend the controlling provisions stipulated in Section 38A of the Constitution, to wit, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies, unquote. It is further submitted that the trigger, if you will, to bring proportional representation system into play for the purposes of elections in the country is, quote, where constituencies do not exist, unquote. Therefore, in the face of existing constituencies and wards, the forthcoming elections for Parliament and ward cannot lawfully and properly be held on the basis of proportional representation. The predicate where in Section 38 is all important in the context of the meaning and effect of the section. The word itself intends to be a technical term in legislative drafting. It normally and best conveys the equivalent of general circumstances or a description of a factual situation. See Legislative Drafting Volume 1 by V. Crabb, 1993, reprint 1998, Cavendish Publishing Limited, page 14. The plaintiffs respectfully urge this Honorable Court to take judicial notice of the fact that the present Parliament comprises members who were elected during the last general elections in 2018 to represent their respective constituencies, and the same applies for the current members of the local authorities. These respective constituencies and wards are in being, vibrant and subsisting. This, it is respectfully submitted, is the pith and substance of the plaintiff's case. There are present subsisting constituencies and wards in the country for electoral purposes. This should, in or by itself, preclude recourse to proportional representation system of elections as provided in Section 38A of the Constitution. It is further submitted that proportional representation as contemplated and provided for in Section 38A of the Constitutional Amendment of Sierra Leone 2001 is itself a product of its time. It is a fallback position when there are no constituencies or wards for the purposes of public elections in the country. This was the rationale and the prevailing circumstances that warranted and justified the amendment introduced to Section 38 of the Constitution 1991 and 2001 as now contained in Section 38A of the Constitution. The country had then just come through a brutal and destabilizing rebel war foisted on the country, which resulted, apart from the loss of human lives and destruction of property, in the destabilization of communities nationwide. An immediate effect of such a situation was the absence of settled communities and constituencies. Hence the justification for the introduction of the proportional representation system. This was in a bid to restore the country to democratic civilian rule. It then was seen as a contingency provision and not intended to be a regular format for public elections or general elections for Parliament. This is borne out by the operative words of the amendment in Section 38A. But constituencies, quote, but constituencies have not been established, unquote. The amendment introduced by Section 38A clearly speaks to a situation where constituencies have not been established in the country. It is further the case for the plaintiffs that these conditions do not now prevail in the country, and therefore recourse cannot lawfully and properly be had to such a system in the face of existing constituencies and wards. Moreover, it is the case for the plaintiffs that the review and possible delimitation of constituency boundaries as provided for in Section 38(4) of the Constitution 1991 is not a viable or tenable excuse and or warrant that in the absence of such review and delimitation, recourse can be had to the proportional representation system as contained in Section 38A of the Constitution. This is so for the simple reason that a review of boundaries of constituencies may or may not result in their delimitation. Section 38A of the Constitution only stipulates the time frame within which such a review may be done. It is further submitted for the plaintiffs that failure to embark on or complete such a review of boundaries exercise does not ipso facto result in the abolition or elimination of such constituencies, so as to warrant the bringing into play of proportional representation system for electing the members of Parliament. Therefore, in the present circumstances, it is submitted for the plaintiff that there is no warrant or justification for the use of proportional representation for the forthcoming elections. It is further submitted for the plaintiff that the use of proportional representation for public elections would negate the possibility of having independent candidates for such election, as is contemplated in Section 77M of the Constitution, which relates to the loss of an elected independent seat on cross-carpeting to a political party. Moreover, it is the case for the plaintiffs that the proportional representation system gives primacy to a political parties list submitted to the Electoral Commission to the exclusion of the constitutional entitlement of every Sierra Leonean subject to the requirement listed in Section 35 of the Constitution 1991 to be entitled to be eligible as a candidate for Parliament. The proportional representation system was intended for the conditions specified in the amending Section 38A of the Constitution, and it was not intended to deprive Sierra Leonean citizens of the right to stand for and be elected as members of Parliament by a mere sidewing, as is now contained in the second defendant's press statement. It is further submitted for the plaintiffs that since exceptional circumstances in 1996 and 2002, when the course was hard for public elections to the proportional representation system, subsequent elections up to the present for parliament and local councils have since been on constituency and ward basis. The exceptional circumstances and the year 2002 marked the official end of the Civil War and the subsequent restoration of parliamentary constituencies. Therefore, it is submitted for the plaintiffs that the use of the proportional representation for parliamentary elections and local councils elections was done in those exceptional circumstances which do not now prevail. Accordingly, it will not be conducive to democratic civilian government in circumstances of a multi-party system to hold public elections now on a proportional representation system, which will be a throwback to an earlier in all matters relating to the enforcement or interpretation, emphasis added of any provision of this Constitution, and B, where any question arises whether enactment was made in excess of the power conferred upon Parliament or any other authority or person by law or under this Constitution, unquote. That is to say, respectfully, this Honorable Court is being asked to interpret, apply, and if possible, enforce by way of granting the several reliefs prayed for by the plaintiff in this matter as contained in the notice of motion. In this exercise, it is respectfully submitted that the task of this court is simple if regard is had to the basic principles and well-established canons of interpretation of statute. It is submitted respectfully that the first of these is that if there is nothing to modify or alter the language of the statute, it must be construed in the ordinary and natural meaning of the words and sentences used. This, it is urged respectfully, is the literal rule of interpretation, which cuts down the ages since the 19th century have employed. See the judgments of Judicial, MI in Attorney General and Mutual Tontine Westminster Chambers Association Limited, and Lord Fitzgerald in Bradcliffe against Clark. Again, it is respectfully submitted that the objective of all interpretation is to discover the intention of the lawmakers, which is deducible from the language used. And once the meaning is clear, the court should give effect to it. The courts are not to repeat, and the courts are not to defeat the plain meaning of an enactment by an introduction of their own words into the enactment. Given the constitutional scheme of Section 38 of the 1991 Constitution, which stipulates that Sierra Leone shall be divided into such constituencies for the purpose of electing the ordinary members of Parliament, unquote, it is submitted that ordinarily such election should be on a constituency basis. We say so because Section 38A, amending the Constitution, envisages an extraordinary situation where no constituencies have been established for one reason or the other. This, on the evidence, is categorically not the case in this instance. See the affidavit of the first plaintiff, paragraphs 1 and 3. It is respectfully submitted that the salient words used by the legislature in Section 38A, amending the Constitution 1991 as follows, quote, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38 for the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing districts in a manner to be known as the district block representation system instead of constituencies, unquote. In plain terms, it is respectfully submitted that the intention of the legislature in enacting this section was clear and simple, namely, where a date for general election has been appointed, but no constituencies exist in accordance with Section 38(3) of the Constitution, then and only then, we submit the President may, after consultation with the Electoral Commission, direct that such an election shall be conducted on proportional representation basis. What is the evidence in this case at the bar? Clearly, from the press statement by the Electoral Commission itself, a date for the general election has been appointed, namely the 24th of June 2023. Also clear as a pikestaff is that there are existing constituencies and wards established pursuant to Section 38 of the Constitution 1991, and the wards under the Local Government Act 204, Boundary Delimitation Regulation 208, and Constitutional Instrument number 2 of 2008, respectively. It is accordingly submitted respectfully that the press statement of the second defendant stating that the 2023 elections will be held on a proportional representation basis finds no validity or affirmation in the clear and plain words of Section 38A of the Constitution. It is further respectfully submitted that Section 38A of the Constitution does not give the President carte blanche power to direct that elections be held on a proportional representation basis regardless of the controlling words of this section, namely, but constituencies, quote, but constituencies have not been established, unquote. It is therefore respectfully submitted that to find or hold otherwise is to fly in the face of the clear words and plain meaning of Section 38A(1) of the Constitution and the weight of evidence in this case. The unconstitutionality of statutory instrument number 83 and 83 of 16 November 2022. Paradoxically, it is to be noted that these statutory instruments, given the same number, purport to address both parliamentary and local council elections, respectively. The claimed warrant or authority for this instrument is Section 33 of the 1991 Constitution. It is submitted respectfully for the plaintiffs that this section confers no warrant or authority as claimed in the said statutory instrument to change the form, format, or mode of parliamentary and local government elections. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make. Section 33 of the Constitution undoubtedly confers on the Electoral Commission the power to make regulations, but such regulations cannot change the form of elections for parliaments and local councils as purportedly claimed in the statutory instruments. It is again respectfully submitted for the plaintiffs that to change the form of election of members of parliament and local authorities is a deliberate matter for primary legislation. The form for electing a member of local authorities is specified in Local Government Act 2004, more particularly in subsection 4 of Section 4. The power given to the Electoral Commission under Section 33 of the Constitution and Section 171 of the Public Elections Act 2002 is to conduct and supervise elections and not to determine the form or mode of elections. To change the format or mode of elections it is submitted a matter for primary legislation, reserved for the legislature, and with respect, not the subject of a statutory instrument. The word conduct in the circumstances does not include prescribing the form of election or changing the electoral system. Section 68 of the Public Elections Act 2022 enumerates what constitutes conduct of election by the Electoral Commission. Nowhere in the entirety of Section 68 Is it suggested that the Electoral Commission can change the form or mode of electoral system? The powers exercised under the statutory instrument by the Electoral Commission are in excess of the powers conferred under Section 33 of the Constitution 1991 and 171 of the Public Elections Act number 17 of 2022. Conclusion. In conclusion, it is urged respectfully that on the law and the evidence, in this case, it will be ultra-vires and unlawful to hold the June 2023 elections on the proportional representation basis for the following reasons. Firstly, such elections on a proportional representation basis would offend the clear provisions of Section 38A of the Constitutional Amendment 2001. This section simply provides that the President, in consultation with the Electoral Commission, may direct the latter to conduct such elections on a proportional representation basis, quote, where constituencies have not been established. Secondly, on the evidence, there are currently established and existing constituencies in the current parliament of this country. Thirdly, the contingent circumstances envisaged in Section 38A of the Constitution as amended are not present to warrant a proportional representation system for the 2023 elections. Fourthly, it will be wrong and impermissible in a democratic state to invest the President with the sole power to order and direct a proportional representation system for public elections without the concurrence of Parliament and in the face of existing constituencies. Fifthly, it is for all these elections that the plaintiffs beseech this Honorable Court to grant the reliefs they seek in their motion. Sixthly, the proposal to hold the June 2023 election on a proportional representation basis would flout and ignore the constitutional scheme stipulated in Section 38(1) of the Constitution. This provides that Sierra Leone shall be divided into such constituencies for the purpose of electing the members of Parliament, unquote, which provision was amended in 2001 by the Constitution of Sierra Leone Amendment Act number 15, 2021, by inserting paragraph A to Section 38 as follows, quote, where under any law for the time being in force, a date for a general election of members of Parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38, for the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a manner to be known as the district block representation system instead of constituencies, unquote. The plain and irrefutable evidence before this court, as per the affidavits of the plaintiffs, is that there are present and existing constituencies in the country for parliamentary purposes. Seventhly, the multi-tier election on a proportional representation, as stated in the statement of the second defendant, finds no jurisdiction in either the Constitution or the country's laws regarding local authorities' elections. Plaintiff's counsel's argument. In his argument before this court, learned counsel for the plaintiffs, Dr. Abdullahi Conte, submitted that this case was not about the merits or demerits of proportional representation system. At the heart of this case, he argued, was the crucial issue of whether the 2023 multi-tier elections involving parliamentary and local councils elections should be held through a proportional representation system, which he concluded strikes at the heart of the rule of law, in that whether we can truly say as a country we are governed by the rule of law and the Constitution of Sierra Leone. He further submitted that the proportional representation was not an alternative system of election in a democratic country governed by the rule of law. He argued that it was Section 38A(1) of the Constitutional Amendment Act number 15 of 2001 that introduced such system, but that it must be read in conjunction with Section 38(1) of the Constitution of Sierra Leone Act No. 6 of 1991, which had imposed a constituency-based election, in which case it must be concluded that Section 38A is not freestanding or ultimate. Thus, he argued, the powers vested in Section 38A of the Constitutional Amendment must be exercised within the parameters of the Constitution Act No. 6 of 1991, which provided that elections be constituencies based as in Section 38(1) thereof. He further submitted that apart from it not being freestanding, this case was about the limit of that power vested on the President and that of the Electoral Commission, and when and how that power to run elections by proportional representation system could be lawfully exercised. He submitted that it was against this background that he was now submitting that the directive given by His Excellency the President to the Electoral Commission for it to run the 2023 elections following the alleged consultation with the Electoral Commission to be ultra-vires the Constitution. He noted that the plaintiffs were not questioning the directive per se, except that it was ultra-vires the Constitution because there were already existing constituencies. He was quick to note that the plaintiffs were further questioning whether the Electoral Commission was right in advising the President to make such a directive when the conditions precedent, in their estimation, has strictly not been met or followed. In this context, the defendant's reliance on Section 53, Sub 3 and 171(14) of the Constitution was plainly out of context and misconceived. The court will no doubt and clearly be performing its role if it declares that the President was wrong in giving this directive when the conditions precedent for holding general elections to a proportional representation system have clearly, in this case, not been met. He relied on the case of Hijina on the application of Miller, appellant, versus the Prime Minister, respondent, Cherry, and others, respondents, versus Advocate General for Scotland, appellant, Scotland, where the Supreme Court in UK had to consider whether the Prime Minister's advice to the monarch was justifiable or not. He observed that this court will do well if it adopted the statement of Lady Haley when in paragraph 34 of the judgment she said that, quote, if the issue before the court is justifiable, deciding it will not offend against separation of powers. The court will be performing its proper function under our Constitution, unquote. Turning to the issue of whether the preconditions for the running of an election via district block proportional representation system were met, learned counsel for the plaintiffs urged the court to consider the two conditions precedent, which must be met as follows. Firstly, one, a date for the general election must have been fixed. Secondly, and most importantly, whether constituencies have not been established. He submitted that the determination of these two crucial issues must be based on evidence and an analysis of the law. Taking the above as the conditions which must be satisfied, he submitted that the answer to the first question as to whether a date has been fixed was in the affirmative, a yes answer. Regarding the answer to the second question as to whether constituencies have not been established, the response he noted was that constituencies had long existed and were subsisting, as evinced by the fact that members of Parliament were currently sitting in Parliament and that the first plaintiff hearing was the Member of Parliament representing one of the 132 constituencies existing, to wit constituency 77 in the Putloko district in the northwestern region of the country. He argued that on the contrary, there was no evidence in rebuttal of the fact that constituencies were existing to show that there were no constituencies existing as required by the preconditions for the use of proportional system of representation. Against the foregoing, he argued any decision to hold the election to proportional representation outside Section 38(1) will be strictly unlawful. Learned counsel for the plaintiffs, Dr. Abdullahi Conte, concluded on this point by submitting that it would be the most unusual and exceptional circumstance that would warrant the holding of a multi-party elections to a peer system of elections and not when there is democracy. He argued further that it was incumbent on the Electoral Commission to provide reasons why it was necessary to change the form of election from a constituency-based first-past-the-post system to a proportional representation system. As far as he was concerned, up to this time, there has been no explanation given by the Defendant Electoral Commission why it had to change the form of elections. He submitted that the lack of explanation must be confusing to the electorate and the general public. In the alternative, however, it appeared he argued also that if there was an excuse of inability or impracticability to complete the exercise of the limiting boundaries which the Electoral Commission of Sierra Leone had started, it was a very lame excuse, and that could only be accepted if the so-called excuse was made through an affidavit and subjected to scrutiny through cross-examination in the court. He submitted that the Electoral Commission has sought to extinguish constituencies unilaterally when such constituencies still subsist. Learned Counsel then turned to the unconstitutionality of what he called statutory regulations numbers 83, what indeed was statutory instrument numbers 13 and 14 of 16th November 2002, to which the Electoral Commission used to put the proportional representation system into effect or operation. Learned Counsel submitted that the second respondent seems to take succor in statutory instrument number 83 and 83 for the setting up of the PR system, but such a power cannot change the form or format of elections, noting and submitting that to change the format or form was a deliberate matter for the legislature in the primary legislation and not secondary instrument. Accordingly, to change the format and mode of elections by statutory regulation, which is secondary, will be plainly ultra-vires. He urged that the word conduct does not include setting the format. He referred to Section 68 of the Public Election Act number 17 of 2022 to illustrate what constitutes regulation for conduct of elections. He concluded by stating that because of the aforementioned, what Electoral Commission, the second respondent, second defendant, did by the said regulations to statutory instrument number 13, numbers 13 and 14 of 2022 was in excess of their powers and accordingly ultra-vires. He therefore urged his lordships to grant the reliefs prayed for. The first defendant, statement of first defendant's case, pursuant to Rule 92.1 of the Supreme Court Rules, 1982. Facts and particulars of the case. The first defendant, who is the Attorney General Minister of Justice, is the principal legal advisor to the government of Sierra Leone, including its ministries, departments, and agencies. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, and local government elections and referenda, and other matters connected therewith, including regulations for voting by proxy. The second defendant, in compliance with its constitutional mandate, the Constitution of Sierra Leone Act number 6 of 1991, hereinafter referred to as the Constitution, on the 21st day of October 2022, issued a press statement in which it stated that on the directive of the President of Sierra Leone, the 2023 multi-tier elections will be conducted using the proportional representation system, as provided for in Section 38A(1) of the Constitutional Amendment Act of 2001, Act number 15 of 2001, and that the boundaries limitation exercise, which had commenced, is halted with immediate effect. That the plaintiff's hearing being dissatisfied with the press statement of the second defendant, on the 28th day of November 2022, filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 1241 of the Constitution. The main plank of the plaintiff's case is that to conduct the 2023 election on a district block representation system would offend the controlling provisions in Section 38A(1) of the Constitution, as the reasons for the in consultation with the ECSL has directed that such election shall be conducted pursuant to Section 38A in a manner to be known as the district block system. Additionally, the ECSL has powers to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38(4) states, quote, "The Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituencies in accordance with the provisions of this section." Further, Section 38(3) and the proviso thereof deals with how constituency boundaries should be determined. The population quota, as referred to in the proviso, is defined in the Constitution to mean the number obtained by dividing the number of inhabitants of Sierra Leone by the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit boundaries, the first thing to do is to divide the population of Sierra Leone to determine the population quota, and thereafter the population quota will now determine constituency delimitation. See subsection 6 of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census. See subsection 7 of Section 38 of the Constitution. Therefore, the undermentioned facts since the 1991 Constitution was enacted, for which we urge Therefore, the undermentioned fact since the 1991 Constitution, for which was enacted, for which we urge the court to take judicial notice of, ought to be borne in mind as we make our submission. A population and housing census was conducted in December 2004. B, thereafter constituencies were reviewed, altered, and delimited in 2007 by the National Electoral Commission, thus establishing 112 constituencies for the purpose of electing members of Parliament for the 2007 general elections. C, another population and housing census was conducted in December 2015. D, constituencies were again reviewed, altered, and delimitation done on the 17th February 2017 based on the 2015 population and housing census. Wherefore, 132 constituencies were established for the purpose of the 2018 election for members of Parliament. In July 2021, a midterm population and housing census was conducted. F, the results were announced on the 15th of September 2022, showing substantial growth in the population figures at regional, district, and chiefdom levels. G, the date for elections for members of Parliament was announced by the President to be on the 24th of June 2023. H, constituencies have not been reviewed, altered, and delimited to be so established for the purpose of the June 24th June 2023 general elections. The Electoral Commission cannot, after the 23rd of December 2022, update and revise the voters' register due to the provision of Section 18 of the Public Elections Act 2022, Act number 17 of 2022, and Article 2 of the EDCOWAS Protocol on Democracy and Good Governance, ASP 11201, supplementary to the protocol relating to the mechanism for conflict prevention management, resolution, peacekeeping, and security, December 2001. Nevertheless, it is the contention of the plaintiffs that the conduct of June 2023 multi-tier public elections based on the district block representation system pursuant to Section 38(1) of the 1991 Constitution as amended in the absence of the condition precedent, namely, quote, where constituencies do not exist, unquote, will be ultra vires and unlawful. The plaintiffs argue that the trigger for the district block representation system is where constituencies do not exist, unquote, quote unquote. They are assertive that there are extant and subsisting constituencies and local council wards pursuant to Section 38(1) of the Constitution and the Local Government Act of 2004, Act number 15 of 2004, and urge the court to so hold. Submissions. It is a submission that the plaintiff's assertion based on their interpretation of the provisions of Sections 38 and 38A of the 1991 Constitution cannot hold in law. The provisions of Section 38 and 38A are being deliberately misconstrued by the plaintiffs. We hereby submit a legal argument and interpretation of Section 38 and 38A of the 1991 Constitution as thus. In the instant case, the provisions in Section 38A were triggered after there had been a population and housing census and the results announced, with a significant alteration in the population growth, but the Electoral Commission for Sierra Leone could not review, delimit, and establish constituencies for the election of members of parliament slated for the 24th of June 2023. The midterm census was conducted in July of 2021 and the final results announced on the 15th of September 2022. Prior to the publications of the final census result, the President announced the date of the general elections, which was slated for June 2023. But the Electoral Commission, after a consultative meeting with the President on the 19th of October 2022, updating him on the progress relating to the boundary delimitation exercise being undertaken and the impracticability of complying with Section 38(3) of the Constitution, necessitated the directive of the President. This directive, so given, was done by an authority conferred on the President by the Constitution under Section 38A(1) of the Constitutional Amendment. The wordings of Section 38A(1) inter alia clearly states, quote, where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of Section 38. For the purposes of such election, the President may, after consultation with the Electoral Commission, direct that such election be conducted on the basis of the existing districts in a manner to be known as the district block representation system instead of constituencies, unquote. Section 38(3) states that, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable, unquote. Section 38(7) states, quote, for the purpose of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuance of an act of parliament, or if no census had been so held, by reference to any available information which, in the opinion of the Electoral Commission, best indicate the number of those inhabitants, unquote. It is a submission that the latest census in Sierra Leone is the midterm census conducted in 2021, for which final result was announced on the 15th of September 2022. Based on the said census results, there was significant population growth from 2015 to 2021 in the regions, districts, and chiefdoms by 6.4%. See page 37 of the final census result, which necessitated the review of constituencies pursuant to section 38, 3, 4, 6, and 7 of the Constitution. Since the Commission was unable to continue the constituencies boundary delimitation exercise based on the latest census result, and the date of the election of members of Parliament has been appointed or announced by the President for the 24th June 2023, and the President, having had consultation with the Electoral Commission on the impracticability of reviewing, altering, and delimiting constituencies, it is therefore prudent for us to reason, and we do submit, that legally constituencies have not been established for the forthcoming election of members of Parliament pursuant to section 38(3) of the Constitution. Emphasis provided. It is fair and just and legal for the President to perform his constitutional duty by directing that the district block representation system be used instead of the constituencies. In effect, the application filed by the plaintiff and the second relief prayed for is contravening the provisions of section 53 sub 3 and 171 sub 14 of the Constitution. These provisions state thus. 53(3), quote, whereby this Constitution or under any other law, the President is required to act in accordance with the advice of any person or authority. The question whether he had, in any case, received or acted with such advice shall not be inquired into by any court, in any court, unquote. 171(14) provides as follows: where under any provision of this Constitution, any person or authority is authorized or required to exercise any function after consultation with some other person or authority, the person or authority shall not be required to act in accordance with the advice of that other person or authority, and the question whether such consultation was made shall not be inquired into in any court, unquote. That this court must have jurisdiction to grant the orders prayed for on the subject matter before it, and that without jurisdiction the whole proceedings become a nullity with no legal effect. That by virtue of the restrictions placed in the above provisions in paragraph 6 hereof, this court has been deprived and lacks the necessary jurisdiction to adjudicate on the second relief prayed for, thus subjecting the President's directive to scrutiny by the court, which is legally wrong. Where the boundaries have not been reviewed to determine the actual inhabitants with reference to the latest census, that is the midterm census, an election on constituency-based system will be in complete violation of the Constitution, particularly so when the date of election has been announced. The argument by the plaintiffs that there is no condition precedent to invoke section 38A is flawed, baseless, and frivolous, and cannot be legally countenanced by this court. The impracticability to comply with section 38(3) and 7 of the Constitution triggers the invocation of section 38A. It is the defendant's submission that section 38A was never introduced into our laws for a specific purpose, as averred by the plaintiffs in paragraph 17, 25, 26, and 27 of their statement of case. Had it been so, it would have been repealed and replaced immediately after 2002 elections. But the drafters of that provision envisioned a situation where there would be a census, but constituencies have not been reviewed, altered, delimited, and established. Hence, the essence of Section 38A. If the drafters wanted to limit the applicability of the provisions of Section 38A to a one-off situation, they would have said so clearly. Furthermore, if it were to be believed that the 2001 amendment to the Constitution was as a result of the war, that would have been wrong, because it would have gone against the principle of posterity, which is one of the objectives for which constitutions, as in this case the Constitution of Sierra Leone, see the preamble to the Constitution of the United States. It is further submitted that contrary to the misplaced reasons proffered in paragraphs 17, 25, 26, and 27 of the plaintiff's case for the 2001 constitutional amendment, the actual reason for the amendment to Section 38 of the Constitution was necessitated by circumstances, quote, circumstance emphasis in which the Electoral Commission finds itself in a situation where a population census has been conducted, a date for the general election announced, but the Commission is reasonably unable to review, alter, delimit, and establish constituencies for the purpose of such election. Following the population and housing census in December 2004, the Electoral Commission conducted a review of constituencies in 2006, wherefore the constituencies were altered, delimited, and 112 constituencies established for the purpose of the 2007 general elections. The plaintiffs argued that the elections for ward councillors cannot be lawfully and properly held on the basis of proportional representation. We adopt our arguments in paragraph 1 to 10 with the necessary modifications to words. Wards boundaries were reviewed and delimited for the creation of 394 wards in 2008 after the 2004 census. We state that by the provisions of Section 33 of the Constitution, the Electoral Commission is empowered to make regulations for the local councils, elections, and Constitutional Instrument number 2 of 2008 vests the authority to review wards based on the national population quota, which is ascertained by reference to the latest census. In this case, the latest census is the midterm census. It is therefore a submission that the constituencies and wards ought to be reviewed for the delimitation and establishment of wards for the purpose of the June 2023 elections, local council elections, as a result of the midterm census. The plaintiff's argument in paragraphs 23 and 24 of their case states that the proportional representation system will negate the possibility of having independent candidate for such election. This assertion is speculative and not legal. Section 75 of the Constitution sets out clearly the requirements for a person to be elected as a member of Parliament, irrespective of the form of the electoral system so used. Once those requirements are fulfilled, nothing stops a person, be it independent or not, from being given the opportunity to contest. To buttress this point, Section 58(1) and 8(c) states, a candidate shall be nominated in writing by 3 voters of the electoral area for which he intends to contest. And 58(c) states, the political party of a candidate as applicable. This simply means not all candidates will be nominated by political parties. The plaintiffs further failed to establish their locus with respect to their case for independent candidates. The plaintiffs are both members of the All People's Congress Party and not independent candidates. They have not established a standing as to this argument, and therefore we submit that their argument in respect of it must not be entertained. That the applicants are further seeking this court to declare statutory instrument number 83 and 83 dated 16th November 2022 based on the argument that the Electoral Commission has acted in excess of the powers conferred under Section 33 of the Constitution and Section 171 of the Public Elections Act. It is a submission that the statutory instruments were laid in the House of Parliament on the 23rd of November 2022 by the Office of the Attorney General and Minister of Justice, pursuant to the provisions in Section 2, subsection 3 of the Constitutional and Statutory Instrument Act 1999. It states that any instrument so laid before Parliament shall have the force of law after 21 days unless before that date it is so defeated by vote of 2/3 majority. The said instruments are yet to have the force of law when the plaintiffs were yet to have the force of law when the plaintiffs filed the application to have it set aside. The application filed is dated the 28th November 2020. That is 5 days after it was laid before Parliament. They have not met any of the requirements for the document to be matured, and yet the applicants are seeking this court to act in vain by declaring it ultra vires. Can this court declare an instrument which is yet to have the force of law ultra vires? Conclusion. By reason of the submissions here, we pray that the orders prayed for, as stated in 1 to 9 by the plaintiffs in the originating notice of motion, be dismissed with cost to the first defendant. First defendant's counsel argument. Counsel's argument. Both defendants opposed the granting of the reliefs prayed for. In the case of the first defendant, they relied entirely on the submissions made in the statement of the first defendant's case filed on the 8th of December 2022. In particular, with regard to the unconstitutionality of statutory instrument numbers 13 and 14 of 16th November 2020, they argue that at the time of filing this originating notice of motion by the plaintiff, that instrument was yet law. But as of now, the instrument has received the certificate of maturity and is now law, in which case it cannot be regarded as unconstitutional. Turning to the issue of whether the conditions precedent for the holding of elections to PR, which related to the first, second, third, fourth, fifth, and sixth reliefs prayed, the first defendant's counsel, Solicitor General, argued that the plaintiffs were not reading Section 38A in full, and that a full reading of it would no doubt bring into focus that it was not that constituencies do not exist, but that they have not been established in accordance with subsection 3 of Section 38 for the purpose of such elections. This, he argued, brought into focus census and its relevance in the delimitation of boundaries for the constituencies. He submitted that a midterm census was concluded with results published in September 2022, which results definitely necessitated a review of the current existing constituencies. However, because of the ECOWAS Protocol and Section 18 of the Public Elections Act number 17 of 2002, it was impossible to conduct any exercise to delimit boundaries without offending the aforesaid provisions. He argued that the advice by the Electoral Commission and the directives given by the President were within the mandate of the law provided in Section 38A. On the issue of independent candidates, Mr. Kowa, the Solicitor General, submitted that no independent candidate has brought a claim before this court, and for that issue to have been raised by a non-independent candidate was against the principle established in the Hinganoman case on local standard, as the so-called plaintiff lacked local standard. He argued further that assuming that the court was inclined to consider the relief prayed for, that the statutory instrument numbers 13 and 14 have made adequate provisions for independent candidates in Regulation 10 thereof. Regarding the second relief prayed for, counsel for the plaintiff, Mr. Osman Kanu, submitted that this honorable court lacks jurisdiction to grant the relief prayed for, to wit, a declaration that the directives by the President to the Electoral Commission of Sierra Leone to hold any public elections for ordinary members of Parliament was ultra-vires, where there are extant and subsisting constituencies. Relying on sections 53, sub 3 and 17114, he argued that the court could not inquire into how that directive was given. He noted the submissions of counsel for the plaintiff and the case relied upon, but noted that unlike England, which has an unwritten constitution, Sierra Leone was bound by a written constitution. He therefore asked that the declaration be refused. Regarding reliefs 7, 8, and 9, he noted that these were all consequential reliefs which would flow if this court were to grant orders 1, 2, 5, and 6. Lastly, he noted and submitted that the plaintiffs have not complied with Rule 89 sub 2 with regards to the affidavit file. Statement of the second defendant's case pursuant to Rule 92(1) of the Supreme Court Rules 1982. The second defendant filed a statement of case, the same which is constituted by 54 paragraphs. Paragraphs 1 to 30, 38, 39, and 40 are produced herein verbatim. The rest I will make reference to as and when necessary. Facts and particulars of the case. The second defendant is the Electoral Commission for Sierra Leone, ECSL, responsible for the conduct and supervision of the registration of voters for and all public elections, referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government elections and referenda, and other matters connected in addition to that, including regulations for voting by proxy. In order to carry out its constitutional mandate, the Constitution of Sierra Leone Act No. 6 of 1991, hereinafter referred to as the Constitution, the second defendant issued a press release on the 21st of October 2022, in which it stated the President of Sierra Leone has directed that the 2023 multi-tier elections will be conducted using the proportional representation system as provided for in Section 38A of the Constitutional Amendment Act of 2001, Act No. 15 of 2001, and that the boundaries delimitation exercise which had commenced will be halted with immediate effect. Dissatisfied with the press statement of the second defendant, on the 28th of November 2022, the plaintiffs herein filed an originating notice of motion to the Supreme Court of Sierra Leone pursuant to Section 124 of the Constitution. The plaintiff's argument are centered on the contention that conducting the 2023 elections on the district block representation system would violate Section 38A of 1 of the Constitution. The issues and situations that should trigger utilizing provisions of the Constitutional Amendment Act 201, which amended the Constitution by introducing Section 38A, are presently not subsisting. Sections 38 and 38A of the Constitution provide for constituencies and elections of members of Parliament and do prescribe proportional representation. The second defendant submits that the President of Sierra Leone, in consultation with the ECSL, directed that the 2023 elections be conducted according to Section 38A in a manner to be known as the District Block Representation System. Additionally, the second defendant has passed to cause a review of constituency boundaries at intervals of not less than 5 years and not more than 7 years. Section 38.4 states, quote, the Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter the constituencies following the provisions of this section to such an extent as it may consider desirable in the light of the review, unquote. The constitutional provision of 38.3 and the proviso thereof deal with how constituency boundaries delimitation should be determined. The population quota referred to in the proviso is defined by the Constitution as the number obtained from dividing the number of inhabitants of Sierra Leone by the number of constituencies into which Sierra Leone is divided under Section 38 of the Constitution. Therefore, to delimit electoral boundaries, the first thing to do is to divide the population of Sierra Leone by the number of seats in Parliament to determine the population quota. Thereafter, the population quota will now determine constituency delimitation. See subsection 6 of Section 38 of the Constitution. To ascertain the population quota, reference should be made to the latest population census, or if no census has been held, by reference to any available information, which in the opinion of the second defendant best indicates the number of those inhabitants. See subsection 7 of Section 38 of the Constitution. From the outset, the second defendant would like to state the following fact for the attention of the court. A population and housing census was conducted in December 2004. B, and it triggered the review, alteration, and delimitation of constituencies in 2006 by the National Electoral Commission, thus establishing 112 constituencies to elect members of Parliament for the 2007 elections. C, a second population and housing census was conducted in December 2015. D, again, the population and housing census of 2015 repeated the same process where constituencies were again reviewed, altered, and the delimitation approved by Parliament on the 17th February 2017. Based on the 2015 population and housing census, 132 constituencies were established for the 2018 elections for members of Parliament. In July 2021, midterm population and housing census were conducted with the results announced on the 15th of September 2022. This statistic shows that there was a significant change in the population, with substantial growth in the population, with figures at regional, district, and chiefdom levels. The President announced the date for the election of members of Parliament for the 24th of June 2023. At this stage, constituencies had not yet been reviewed, altered, and delimited based on the trend and practices shown above. That after every census, the outcome should lead to the delimiting of boundaries for the forthcoming elections of the 24th of June 2023. The second defendant is legally barred
Most countries in Africa have been struggling to maintain long-serving electricity services, but over the years, most of those countries have failed, and as a result, many other sectors like health, business, education have been negatively impacted. To help salvage this problem for life is why the Central University, One Silicon Hills Mile 91 Tongolele district in Sierra Leone, has decided to establish a renewable energy department to help train and equip young minds to create a lasting solution to not just Sierra Leone's energy supply problem, but the entire Africa and the world at large.
We believe that as a department will help in setting the way for Sierra Leone and other countries in the African continent to advance their renewable energy systems. We also believe in vertical as well as theory. With the two, we know we can build strong minds to help countries within the African continent benefit from their natural resources like the sun, wind, hydro, biomass, geothermal, and many other sources.
For potential students to understand and respond to this continental problem, the university has established solar farms backed up with strong power systems to help students realize their skills. Trained and qualified staff are all on the standby to guide potential students.
What we'll be doing here will be different from what is practiced in other places, because here we focus on training our students not just to understand ideas related to the course, but will help them set the pace in creating solutions to renewable energy problems in their communities, countries, and beyond. Also, with the guidance of our well-trained staff, we are sure that we'll be able to help our students apply these practical solutions in shaping the renewable energy sector.
Be part of the renewable energy family at the University. And together, let's join in the fight to respond and repurpose our national and continental energy system to become resource efficient from natural resources for decades to come.
You know your rights, speak out. Nothing. You stop us all.
Most countries
From speaking out our rights. Young girls, not rights. You know our rights. We speak them out. Young girls, not rights. We know our rights.
I decided to do the Bachelor of Business Information Technology because it's my area of interest and it provides an excellent opportunity for employment in the ICT field. The course combines aspects of IT and business and one option which makes it a very marketable course when it comes to the job market. Central University is fun. I'm really happy with the course because it's very practical and enjoyable. It does not only focus on the core business IT modules, but also concerned with the human character for information, which makes students all-rounded. I love the fact that there is also a strong emphasis on extracurricular activities, such as sports, clubs, conferences, among others. The course covers elementary business management modules and a variety of IT modules, such as programming, operating systems, artificial intelligence with specialization options of networking and database administration. Here in Central University, we are given the opportunity to do internship with top-notch industries in ICT. Depending on your area of interest, the options available are those of project managers, software developers, network and database administrators, system analysts or what they call hybrid managers. However, with a wide spectrum of innovative ideas, we are highly encouraged to understand entrepreneurship, which is the way forward.
The discipline of mass communication does not matter at any time than now, when the world has become a global village. Now we have to communicate in a global voice when the local audience get along. The ability to use the 21st century media tools as an end user and also the most sophisticated tools, either online or offline with professional tutoring at every level, that is what we provide.
A place cannot produce poems. It can only not.
I know my study in the media is top notch,
and
I can compete
been established
at global
under
level.
subsection 3 of section 38, unquote. The said subsection of section 38 provides that the electoral boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable. To determine this population quota, the 1991 Constitution directs in that section 7 of subsection 38, quote, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of population held in pursuance of Act of Parliament. It is further submitted that on the 17th of February 2022, the boundaries delimited in 2017 reached the 5 years minimum threshold. The law allows the government through statistics to conduct a housing and population census to show the correct and accurate habitation of the people of Sierra Leone. This led to a mid-term census, and once statistics presented the census to the second defendant, it was bound to review the boundaries of the existing constituencies to ensure elections are conducted on the accurate population density and as representative of the sparseness of the population. The only figures that would genuinely represent the present-day Sierra Leone population shall come from the latest census conducted by the legal authority. In this case, the census figures are the midterm outcome, and it will be erroneous and unfair to leave those recent statistics and use an old 2015 census outcome. The 1991 Constitution is very instructive when it provides in section 38(7) that, quote, for the purposes of this section, the number of inhabitants of Sierra Leone shall be ascertained by reference to the latest census of the population of Sierra Leone held in pursuance of an act of parliament, or if no census has been so held, by reference to any available information which, in the opinion of the Electoral Commission, best indicates the number of those inhabitants, unquote. It is clear from the figures of the midterm census that a significant population shift and growth in specific regions, districts, and chiefdoms have occurred, and which makes it imperative for ECSL to review the boundaries that constitute the constituencies as provided in section 38, 3, 4, 6, and 7 of the Constitution. It is the second defendant's informed position that there was and is a need to review the existing boundaries due to the shift in population. The 2017 electoral boundaries cannot be regarded as legal because they have to be established under the recent census and cannot inform the population distribution for the forthcoming elections. The second defendant's legal role is to advise the President on what is doable, feasible, and practicable, considering all the circumstances at a given time, advising the President on a proportional representation system in the face of the impracticability of delimiting the boundaries, but fair, just, and legal. Based on the impracticability of fully complying with section 38(3), the second defendant, with the vantage of unique and specialized knowledge information, advised the President of the eventuality of section 38A. The President so directed in exercising was triggered, and the President was bound to exercise his powers under section 38A by giving the directives as he did to the ECSL. While the state will argue this, ECSL believes that the directives given by the President touching on using a district block representation system of the June 2023 elections were done in good faith, followed the dictates of the spirit, letter, and intent of the wordings of section 38A of the 1991 Constitution. The wording of section 38A, among other things, clearly states that, quote, where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of section 38 for such election, the President may, after consultations with the Electoral Commission, direct that such election shall be conducted based on the existing districts in a manner to be known as a district block representation instead of constituencies, unquote. Considering that the Constitution provides that elections shall be held every 5 years, and a date has been announced to that effect, where the boundaries have not been so reviewed to determine the actual inhabitants with reference to the latest census, that is the midterm census, an election on the constituency-based system will be in complete violation of the Constitution, particularly so when the date for the election has been announced. Any election held leaving out a midterm census would not only be illegal, but a flagrant violation of constitutionalism, which underscores the spirit of democratization. The second defendant will argue that the constituencies and wards cease to exist since Statistics Sierra Leone legally conducted the country's population census under the power conferred on them by law. To counter the existing midterm census result, a new census have to be undertaken, or the extant midterm census be declared illegal by a competent body with the power to do so. It is the second defendant's position that in the absence of legitimate boundary delimitations by the second defendant, elections for both ordinary members of parliament and local council can only be conducted according to the provisions of section 38A of the 1991 Constitution. The plaintiffs argue that there is no condition precedent to invoke section 38A. As explained in paragraphs 5, 6, 7, 8, 9, and 10, the mere impracticability of delimiting boundaries in the face of a significant shift in the population density in the country is enough for a condition precedent to surface and summon section 38A. The point is mute, misplaced, and flawed, and should be discounted by the court. The second defendant submits that the provisions of section 38A are neither transient nor transitional. It was not introduced into the laws just for the worst situation, as the plaintiffs in paragraphs 17, 25, 26, and 27 of their statement of case have said. The draft's new conditions would occur when constituency elections will be impracticable and a remedial provision was needed. If they wanted it to be transitional or transient, they would have said so. It is also the defendant's submission that in 2016, in the final report by the Constitutional Review Committee, made up of 80 members, including representatives of all political parties, they all agreed on pages 260 to 61 that the proportional representation system was a more democratic way to conduct an election for members of parliament. That there are over 80 stable democracies that practice different forms of proportional representation. Among these countries, we have Switzerland, where most of the United Nations offices are housed and which has enjoyed peace and stability since the First World War. Rwanda, one of the most peaceful, prosperous democracies on the continent of Africa, now have gone through a brutal civil and tribal war. New Zealand, Norway, Spain, to name a few. The plaintiff's submission that the PI is not conducive to a democratic civilian government is factually and materially incorrect and aimed at deceiving this honorable court into accepting their case. This court should not countenance this argument. Second defendant counsel's argument. In his argument, second defendant's counsel did say they will rely on what the first plaintiff has said in addition to what he was saying. In his argument, Defense Counsel Dr. Emmanuel Safa Abdullah concentrated on the reason why the Electoral Commission was compelled to take the action of advising the President and the fact that the Plaintiff's Counsel had said that there was no reason, or the reason being very weak. He posited an 8-part test to determine whether the second defendant, the Electoral Commission, acted beyond its powers as follows. 1, whether the Electoral Commission acted reasonably. 2, whether the Electoral Commission had followed due process. 3, whether it is within the limit of that institution to do what they did. 4, whether the decision is rational and evidence-based. 5, whether the decision was taken in good faith. 6, whether the decision was published after it was taken. 7, whether the decision served proper purpose. And 8, whether proper consultation was made. He submitted that the decision of the Electoral Commission met all these requirements. Turning to the issue of local government, he submitted that there has never been a law for local government elections, except in the Public Elections Act and through regulations which are made pursuant to Section 33 of the Constitution of Sierra Leone 1991. He concluded that with the new census results, it was necessary to delimit boundaries of constituencies, which Electoral Commission was unable to do because of the ECOWAS Protocol and Section 18 of the Public Elections Act 2022, which meant that laws for elections must be settled before 6 months to the elections, and to use the current constituencies will be most undemocratic, as it would exclude a lot of people who have been captured by the recent census, which was showing an increase in population of 57,000 plus people spread across various districts and localities. He urged the court to refuse the reliefs prayed for. That is what they have said. Now it's our turn. The ball is in our court. Consideration of the issues. The issues to be determined in this case are as follows. 1. Whether on a proper and purposive interpretation of Section 38A of the Constitutional Amendment Act number 15, 201, the controlling provisions stipulated in subsection 1 thereof, namely, but constituencies have not been established, are conditions precedent to warrant or justify the holding of general elections of ordinary members of Parliament by district block system, hereinafter referred to as the proportional representation system. 2. Whether the directive by the President to the Electoral Commission of Sierra Leone, ECSL, to hold any public elections for ordinary members of Parliament by the proportional representation system where there are extant and subsisting constituencies is altered by the Constitution Act number 15/201 as amended. 3. Whether the current Parliament was itself elected on a constituency basis as provided for in Section 38, 1, 2, and 3 of the Constitution Act number 6 of 1991, and that these constituencies are still extant and subsisting. 4. Whether the revision of constituencies as provided for in Section 38(4) does not necessarily result in the establishment of constituencies stipulated in Section 38, 1, 2, and 3, but rather the section provides for the period when existing constituencies should be reviewed, which revision may or may not necessarily result in a delimitation of the respective boundaries of existing constituencies. 5. Whether relying on Section 38A of the Constitutional Amendment Act number 15/201 will preclude independent candidates from contesting for Parliament as contemplated in Section 77M of the Constitution 1991. 6. Whether the entirety of Section 38A of the Constitutional Amendment of 201 does not provide or contemplate local councils, proportional representation system, elections, and whether the word basis on which local councils are elected is the subsisting and only lawful basis on which any public elections involving local authorities can be held, and not a proportional representation system. 7. Whether Section 2 of Statutory Instruments numbers 13 and 14, dated 16th November, making provisions for representation by both members of Parliament and local councils, is altered by Section 33 and 38 of the Constitution Act number 6 of 1991. I will now deal with these issues seriatim. Whether on a proper and purposive interpretation of Section 38A of the Constitutional Amendment Act number 15/2001, the controlling provisions stipulated in subsection 1 thereof, quote, but constituencies have not been established, are conditions precedent to warrant or justify the holding of general elections of ordinary members of Parliament by the district block representation system, hereinafter referred to as the proportional representation system. In the consideration of this issue, one will note firstly that the plaintiffs are arguing that the controlling provision is namely, quote, but constituencies have not been established, and that this is a part of the condition, that this is part of the conditions precedent which must be established, and which has not been established. Hence, the reason why proportional representation at this point in time, when according to them constituencies do exist, cannot be applicable or be the mode or form of elections for the 2023 elections, and by extension, do not justify the holding of elections by such means as adopted via the public announcement via the press statement of 21st October 2022. This is clearly seen from the plaintiff's argument, wherein they have sought to present it thus, that as a result of the provisions of Section 38(1) of the Constitution Act number 15 of 2001, it would be ultra-vires that provision and unlawful to hold the June 2023 multi-tier public elections in the country via a proportional representation system using the district block system. For as they put it, the plain and simple reason that the condition precedent according to them for bringing into effect those provisions in Section 38A are, quote unquote, where there are no constituencies, which at this very moment is not the case in the country, courtesy of the fact that there are extant and subsisting constituencies in operation pursuant to Section 38(1) and 2 of the Constitution. That is to say, the trigger, according to them, to bring proportional representation into operation is, quote unquote, where constituencies do not exist. And as is explicit to all concerned, there are consistent constituencies existing, 132, of which the plaintiff is the representative or member of parliament for constituency number 77 in the Port Loko district. Predicated on the above, the district block representation has already been put into place by the Electoral Commission will be ultra-vires the very provision which establishes such a system of representation in Parliament, in consequence of which they are seeking the assistance of this court to stop the Electoral Commission from carrying out the district block representation system in place of the constituency-based form of representation which has usually been the case. The defendant's reply is that the plaintiffs have given a very restrictive meaning of Section 38(1) of the Constitutional Amendment, and that Section 38A has never, in fact, provided as they are arguing to be the case. They claim Section 38A(1) has not stated or never stated where constituencies do not exist, but that rather that section be read as a whole, to wit, where under any law for the time being in force, a date for a general election of members of parliament has been appointed, but constituencies have not been established in accordance with subsection 3 of section 38 for the purpose of such election, the President may, after consultation with the Electoral Commission, direct that such election shall be conducted on the basis of the existing district in a matter to be known as the district block representation system instead of constituencies, unquote. They submit that without the fresh or new delimitation of constituencies after the publishing of census results by Statistics Sierra Leone, legally speaking, constituencies have not been established for the forthcoming elections of members of parliament pursuant to section 38A of the Constitution as amended, and that this is exactly the way they have read it, hence the imposition of the district block system. Section 38(3) of the Constitution Act number 6 of 19 provides, quote, the boundaries of each constituency shall be such that the number of inhabitants thereof is as nearly equal to the population quota as is reasonably practicable, provided that the number of inhabitants of such constituency may be greater or less than the population quota, in order to take account of means of communication, geographical features, density of population, the distribution of different communities, the areas and boundaries of the chiefdoms and other administrative and traditional areas, unquote. The defendants infer from this section that by the words but constituencies have not been established is not saying, quote unquote, but constituencies do not exist, or where there are no constituencies, as the plaintiffs are arguing, but rather that constituencies have not been established based on the current population trend as dictated by the recently conducted census, which does and will always affect population quota and the eventual boundary delimitation of constituencies and the number of constituencies for purposes of elections. The defendants refer to section 38(6) and 7, which goes on to explain the population quota as mentioned in section 38(3), which is the controlling section as to how such constituencies must be established for purposes of elections, the 2023 elections not being an exception. This is a process which would take time, as explained by the second defendant's counsel in paragraph 11H and 17 of the second defendant's case, and also beyond their control with the recent publication of census results by Statistics Sierra Leone. The second defendant on their own had started a review pursuant to section 38(4), but with the population census figures received, it became necessary to establish population quota and delimit boundaries, which was going to take time, and noting the law, section 18 of Public Elections Act number 17 of 2022, and the ECOWAS Protocol on Democracy and Good Governance, supplementary to the protocol to mechanism for conflict prevention management, article 2.1 under elections, which states, quote, that no substantial modification shall be made to electoral laws in the last 6 months before the elections, except with the consent of a majority of political actors. They will not be able to meet those timelines set. From the above, it is clear to me that there are two positions regarding the true meaning of section 38A and its applicability. This calls for interpretation, and this is what the plaintiffs have sought to invoke by their seeking of the aforesaid declaration pursuant to section 124 of the Constitution. Interpretation of statutes is the art of discovering the true meaning of an enactment by giving the terms of any enactment its actual or true meaning. As a court, or as judges, we do not interpret arbitrarily, but according to set standards or rules developed over the ages called rules of interpretation. The scope of our work in part of this judgment is to discover, discern, or decipher the true meaning of section 38A as expressed explicitly or implicitly in the language used. Taking the above into consideration as our mandate, I say that on a full reading of section 38A, it shows the section has 4 parts. Condition precedents. 1. Where under any law for the time being in force, a date for a general election of members of parliament has been appointed. Condition precedent number 2. But constituencies have not been established in accordance with subsection 3 of section 38 for the purpose of such elections. Advice by the Electoral Commission. The President may, after consultation with the Electoral Commission, powers of the President, direct that such election shall be conducted on the basis of the existing districts in a manner to be known as district block representation system instead of constituencies. This court's position is that 1 and 2 supra are conditions precedent. The plaintiff argued that those conditions precedent were not met, whilst the defendants say they were met. Regarding the first condition precedent, the opposing parties agree that it was met. The evidence is clear before this court that pursuant to sections 57 and 103 of the Public Elections Act number 4, 2012, which was the law for the time being in force, on the 12th March 2022, a proclamation was made by His Excellency the President, with the same published on the 14th of March 2022, by which the dates for election of paramount chief members of Parliament and ordinary members of Parliament was appointed as 23rd of May 2023 and 24th of June 2023, respectively. Turning to the second condition precedent, this is where the real dispute exists. The plaintiffs want this court to interpret, quote, but constituencies have not been established to mean, quote, but constituencies do not exist, unquote. While the defendants want this court to read, but constituencies have not been established with the connecting words therein to it in accordance with subsection 3 of section 38 for the purpose of such election, unquote. Uncertainty or ambiguity about the meaning of words can arise because of the way words are linked together. This is particularly the case where particular phrases are used. Some of these phrases include in respect of, subject to, in connection with, by reason of, and as in this case, in accordance with, quote unquote. They are nothing more than connecting phrases and indicate some connection or relation between two subject matters or sections to which the words refer. The first step or starting point for interpreting statutes, however, is always the words used, couched in what is referred to as the literal rule. The literal rule in simple language is where the courts simply look at the words of the statute and apply them as they are written, giving them their ordinary and natural meaning. In the case of Franklin against Attorney General, 1973, All England, Lawson J. opined as follows, quote, now if I get to this second stage, then, in my judgment, and then only am I entitled to look at extrinsic aids such as the long title, the heading, the side notes, or the legislation, then only am I entitled to resort to maxims of construction, of which counsel for the plaintiff gave me a useful list. I have to construe the words so that they have reasonable effect. I have to avoid absurdity or repugnancy. I have to avoid hardship and injustice. I've got to be sure that the meaning I select, if the meaning is ambiguous, is a meaning which does not unduly or unjustly interfere with subsisting rights. But in my judgment, I cannot use any of these extrinsic aid. I cannot resort to those maxims unless my answer on stage 1 is the meaning of those words is not clear and not ambiguous. Unless my answer on page 1 is the meaning of those words is not clear and not ambiguous. With similar tenor, Jessel MR in the case of Attorney General against the Mutual Tontine Westminster Chambers Association, he noted that if there is nothing to modify or alter the language of the statute, it must be construed in the ordinary and natural meaning of the words and sentence used when he said, quote, in construing legal arguments, whether acts of parliament or not, it is the duty of the courts to give every term used its ordinary and legal meaning, unless there is something either in the nature of the subject matter or in the context which compels the court to come to a different conclusion. Consequently, it is for those who say that the word is not used in the instrument in its ordinary legal acceptation to show something grounded on one or other of these considerations to prove that it is so used. In Bradcliffe against Clark, 1883, 8 appeal cases, House of Lords decision, Lord Fitzgerald said, I prefer to guide my judgment by the rule of construction laid down in Warburton and Loveland, 1 Hodgson and Brooks, 648, so often quoted, approved of, and followed. Mr. Justice Burton there says, quote, I apprehend it a rule of construction of statutes that in the first instance the grammatical sense of the words is to be adhered to. If that is contrary to or inconsistent with any expressed intention or declared purpose of the statute, or if would involve any absurdity, repugnancy, or inconsistency, the grammatical sense must then be modified, extended, or abridged, so far as to avoid such inconvenience, but no further. So in the interpretation before us, the literal rule becomes a first stage or first port of call for a successful interpretation of the section at hand, section 38A1. The language of section 38A1 now before us does not appear to me to be open to ambiguity, except that one has been created because of the divergent interpretation given to the phrase. But constituencies, quote, but constituencies have not been established in accordance with subsection 3 of section 38 for the purposes of such election, unquote. The plaintiffs are reading, quote, but constituencies have not been established in accordance with subsection 3 of section 38 for the purpose of such election, unquote, to mean where constituencies do not exist, quote unquote, or where there are no constituencies, quote unquote. And since constituencies still exist, unlike a situation where there are no constituencies, the proportional representation district block cannot be put in place. Firstly, the ordinary meaning of that section has never said that. The plaintiff's counsel, it would seem, is importing words into this section. Interestingly, at paragraphs 29 to 33 of the plaintiff's statement of case, the plaintiffs are noted for saying, quote, again, it is respectfully submitted that the objective of all interpretations is to discover the intention of the lawmakers, which is deducible from the language used. And once the meaning is clear, the court should give effect to it. The courts are not to defeat the plain meaning of an enactment by an introduction of their own words into the enactment, unquote. This, no doubt, and as clear as day, flies against the plaintiffs and their counsel, as it is they that are putting words into the legislation. Secondly, the plaintiff's interpretation has not taken any regard to the connecting words or phrases used. Quote, in accordance with. This, like some common phrases that appear in legislation, such as in respect of, or in relation to, subject to, and in connection with, indicates some connection or relation between two sections or subject matter to which the words refer, in order to get its full, broad, or correct meaning. In this case, we adhere to the grammatical sense as leading to no absurdity or repugnancy. The grammatical sense is not inconsistent with the purpose as gleaned from the annotation, among others. In the annotation to this Amendment Act, Section 38A1, we find the words election by district block system. Noting the importance of annotations, headings, and marginal notes serving as useful indicators to all interpretation, would JSC, Justice of the Supreme Court, as she then was, in the unanimous decision of the Supreme Court of Ghana in the case of Anti and Ajua against Ogbo, 205 to 206, Supreme Court Ghana Law Report 494 at 504-505, explain the assistance to be garnered from headings and marginal notes in the interpretation of a statute in the following terms. Quote, as clearly provided under Section 4 of the Interpretation Act 1960, the comparable section of Section 15 of Act 792, headings to parts of a statute, do not form part of the statute. They are intended for convenience of reference only, but the useful role they play in statutory interpretation is not disputed. Headings, which may be described as signposts, are a useful guide in determining the scope or ambit of the provisions to which they relate, unquote. Given its plain and ordinary meaning, quote, but constituencies have not been established, is saying, but constituencies have not been set up, inferring a setting up process in accordance with section 38(3) as the controlling provision, hence the word in accordance with. This setting up process begins with a census which is out of the Electoral Commission's reach or control within the remit of Statistics Sierra Leone. 2. Boundary delimitation of constituencies under which Electoral Commission would A. establish a population quota pursuant to section 38(3) and 38(6), which according to the Constitution is number of inhabitants census results divided by the number of current constituencies. 3. Get the proposed boundary delimitation of constituencies approved by the current Parliament for use after dissolution of Parliament and the next elections. This, to my mind, is the reason why it is stated in section 38(1), but constituencies have not been established in accordance with section 38(3) for the purpose of such elections. Unquote. Taking the whole section 38 and 38A into consideration, this court holds that the default position is that for elections of ordinary members of Parliament, there must be constituencies. However, to establish constituencies, it is not an issue of think of a number and dividing districts into such numbers. It is based on several factors, like first and foremost, population centers, population quota, number of current constituencies, and the like. And where the Electoral Commission is unable to establish constituencies based on these dictates, the alternative is for them to advise the President on such status, who may or may not direct as within his power the form of election who may or may not direct as within his power that the form of election depart from constituency based to a district block representations using the existing districts. This is what Parliament did by its Constitutional Amendment Act number 15 of 2001. The purpose, as quite seen in the annotation thereto, and from the Act itself, is for a district block representation system. It is not a one-off situation, but one which might come up if the establishment of constituencies are not done well in advance of time to be taken into consideration during voter registration and long before 6 months to the elections. Since 2001, governments have come and gone. Parliament did not repeal it. They even had an opportunity to repeal same when the Speaker brought it to their notice. Pursuant to section 108, it is not an enshrined provision which required a cumbersome process to change. But they did not change section 38A. Parliament is the law-making body. If they had wanted, they would have done it. This they did with the restoration of the right of appeal in court-martial cases in 2005, following the denial of that right since 1971. As judges, we can only interpret what we see, and that is what I have done. What is important in any election is the citizens' right to vote. It has not been affected, and it will not be affected, no matter the system, whether constituency-based or district block representation system. Having tested these provisions on the literal meaning, which is clear and unambiguous, I think it is perhaps better if I move one step further and try to confirm it on a modern approach, the purposeful interpretation. In Legislation and Statutory Interpretation by Cathall and Claire Mackens, 3rd edition published by LexisNexis, the learned authors wrote, quote, "Since the 1980s, the court's approach to statutory interpretation has significantly changed. Today, courts are statutorily required to consider both the meaning of the words and the purpose behind the legislation, and this has led to a more balanced and effective approach to resolving ambiguity. The purposive approach means the court must give primary importance to the purpose or object underlying legislation when interpreting provisions of an act. In the case of Abu Ramadan against Nimakor Electoral Commission and Attorney General 2023-2024 to Supreme Court, Ghana Law Report 1654, the Supreme Court of Ghana stated regarding portions of the Public Elections Registration of Voters Regulation 2012 CI 72 Parwood J in part as follows, quote, established principles of statutory interpretation require that CI 72 be read as a whole, not piecemeal and purposively construed and with the impugned legislation interpreted in the context of the other parts, unquote, of CI 2072. To this end, I take sections 38 and 38A as a whole and hold that the purpose of this section is clearly establishing two systems of voting. One, constituency-based form, first past the post. Two, a district block representation system, the proportional representing. Any of same may happen depending on the prevailing circumstances at hand. Having regard to its object and purpose as gleaned from the annotation and the purpose for which this amendment was put in place, it does not present to my mind any such difficulty in interpreting as to warrant us departing from or adding to the ordinary sense of its term, and I give effect to every word of it. From the totality of the interpretation, taking sections 38 and 38A into consideration, one can easily conclude that where there is a population census, number of constituencies are likely to change. They are likely to change, as evidenced from the fact that in 2004, a population and housing census was conducted in December 2004, based on which constituencies were delineated and or established. 112 in total for the purpose of electing ordinary members of parliament for the 2007 election. For the 2012 elections, there was no population set, hence no change in the number of constituencies, which remained the same at 112. Things were so static that in section 56 of the Public Elections Act number 4 of 2012, it stated members of parliament shall comprise be 112 members. However, in 2015, there was another census which resulted in the altering of the population data and or quota. The resultant effect was that despite the Public Elections Act number 4 of 2012, which had stated categorically in section 56 thereof that members of parliament shall be 112, because of the primacy and supremacy of the Constitution Act number 6 of 1991 and how constituencies ought be established via the process to elections, constituencies had to be established based on the census of 2012. This was done on the 17th of February 2017 and formed the basis under which the 2018 elections were conducted based on 132 established constituencies instead of 112 constituencies that had hitherto existed based on 24 census and by operation of law, the Public Election Act number 4 of 2012, section 56B thereof. The census results used were published 3 years before the elections of 2018, and also the delimitation of boundaries was approved in 2017, about a year or more, and most importantly, before the announcement of the date to the election. This, no doubt, is different from what we now have, where the date for the elections had been announced 15 months before the set date for the elections. Also in 2021, a mid-term population census was conducted, for which the results only came out on the 15th of September 2022, after the date for the election has been well appointed in advance since March 2022. And one can take judicial notice of the fact that in September 2022, registration of voters was ongoing. The natural thing to have happened was for the Electoral Commission to now delimit constituency boundaries. This, according to the second defendant, was to take time. See paragraphs 11 and 17 of the second defendant's case. The defendants were on a trajectory to review constituencies pursuant to section 38(4) when the census results were published, taking its implication on board, to wit, establish population quota, delimit constituency boundary, get parliament to approve, saying, get voter registration to reflect such constituencies and wards. Such was likely not to meet the deadline of 24th December 2022, set by section 18 of the Public Elections Act 2022 and the ECOWAS Protocol on Elections, the process had to be abandoned in favor of the district block under which the Electoral Commission believed they will meet timelines. In the exercise of their functions, the Electoral Commission is guided by Section 32(11), which guarantees them independence in the exercise of their function, and we are inclined to support and uphold that independence. In this case, it is for the plaintiffs to show something either in the nature of the subject matter or in the context in which the words are used, which compels this court to come to a different conclusion from the grammatical sense. They have not done that. If anything, on the doctrine of harmonious construction, one can easily see that there could have been no other interpretation better than that which we have adopted. The doctrine of or rule of harmonious construction is to the effect that a provision in the Constitution or statute should not be interpreted or construed in isolation, but as a whole, so as to remove any inconsistency or repugnancy. Under this rule, there is obligation placed on the courts to avoid a clash on contradicting provisions, and courts must construe the opposing provisions in a way as to harmonize the conflicting provisions. The doctrine is based on the principle that every statute or the Constitution does have a purpose, and the provisions should be read in totality and not in compartmentality. The doctrine may become necessary for application where there arises inconsistency between sections of the particular statute or the Constitution. After the statute or act of Parliament has been passed, the legislation no longer has jurisdiction and is functus officio. We, being interpreters, are then unable to question or get back to the legislature to request the exact interpretation of the legislature while they were making it, or even sometimes they may not have even considered such broad range of circumstances at the time of drafting or consideration. In Commission of Income Tax against MS Hindustan Bulk Carriers 203 3SS 57, page 74, the Supreme Court of India, it's a Commonwealth country, they have persuasive laid down 5 principles that govern the rule of harmonious construction as follows. 1, firstly, courts should try and avoid a conflict of seemingly disputing provisions. An effort must be made to construe the disputing provisions so as to harmonize them. 2, the provision of one section cannot be used to overthrow the provision covered in another section unless the court is unable to find a way to settle the differences despite all efforts. 3, in a situation where the court finds it impossible to entirely reconcile the differences in inconsistent provision, the courts must interpret them in such a way that effect is given to both provisions as far as possible. 4, courts must also take into consideration the interpretation that makes one provision redundant and useless is against the essence of harmonious construction. 5, harmonizing 2 contradicting provisions does not mean you render them fruitless or destroy any statutory provision or render it ineffective. Could it be doubted that if we go by the plaintiff's interpretation, this would render Section 38A redundant and ineffective for all times? That cannot be the intention of Parliament. If they want that, they are lawmakers. They must change the law. Remove that law from our books. Until that is done, Section 38A cannot be freestanding, ultra-made, or a one-off situation. There can be no doubt that while we have 2 separate sections to dealing with 2 separate forms of conducting elections, that the interpretation we have given makes Section 38A to fit in nicely and in sync and harmoniously with Section 38 to be applied when the circumstances in the country as at now has dictated, and I say no more. Second issue, whether the directive by the President to the Electoral Commission of Sierra Leone, ECSL, to hold any public elections for ordinary members of Parliament by the proportional representation system where the extant and subsisting constituencies is ultra vires the Constitution Act number 15/201 as amended. Learned Counsel for the Plaintiff has respectfully submitted that Section 38A(1) of the Constitution does not give the President carte blanche power or unconditional authority to direct that the elections be held on a proportional representation system, regardless of whether the conditions precedent were fully met. He claims that because there were extant and subsisting constituencies, the so-called advice by the Electoral Commission was wrong in law, and so too the directives which emerged. Even though as per Section 53(3) and 171(14) of the Constitution, a court cannot inquire into the consultations where the directives were based on a supposed wrong presupposition to wit that constituencies have not been established, when according to him constituencies have existed and were still subsisting. This court has jurisdiction to make a declaration that the President acted beyond his powers. The defendant's response was that this court lacks jurisdiction to so declare because of Section 53(3) and 171(14) of the Constitution. This court does state that it has jurisdiction to hear what the plaintiff's inquiry is all about. Our inquiry is not whether His Excellency the President has received or acted with such advice, but whether the directive given by him is in tandem with and intra vires the law as prescribed, which the President himself, as fountainhead of justice and primary upholder and defender of the Constitution, is enjoined to observe, or whether his action to direct the Electoral Commission to use the district block representation system for the 2023 June elections was outside or in excess of the powers so conferred on him by Section 38A(1) of the Constitution. In Regina against Hall University Visitor Ex parte page 1993-2, Appeal Cases 237, Lord Brown Wilkinson said in defining what is meant by ultra vires, quote, if the decision maker exercises powers outside the jurisdiction conferred in a manner which is procedurally irregular or is winspiri unreasonable, is acting ultra vires his powers and therefore unlawfully, unquote. Taking the above into consideration and having come to the conclusion that the preconditions or condition precedent were fully met, His Excellency the President's action are therefore procedurally regular and winspiri reasonable, making the inquiry academic. In that sense, in that those directives were well within his mandate and were lawfully made and can in no way be declared as ultra vires. Third, inquire whether the current Parliament was itself elected on a constituency basis as provided for in Section 38(1), 2, and 3 of the Constitution Act number 6 of 1991, and whether these are still extant and subsisting. The plaintiffs are seeking declaration as a way of interpretation and enforcement of the Constitution that the current Parliament was elected on a constituency based as provided for in Section 38(1), 2, and 3. There can be no doubt that this was the case. Even when Section 56 of the Public Elections Act number 4 of 2012 provided that the current Parliament after 2012 was to be 112 members, the evidence before this course is that following the 2015 census, which altered Sierra Leone's population from that which was the case in 2004, the number of seats in Parliament or constituencies with MPs rep changed from 112 to 132 as a result of boundary delineation or delimitation exercised in 2017, which flowed from those census results. See paragraph 11 from each of the first and second defendant's case. When that happened, the previously 112 constituencies lasted up and until the dissolution of that Parliament for the 2018 elections, which saw the establishment or introduction of the new constituencies approved by that old Parliament. Those previously 112 constituencies, by and large, by the dissolution of Parliament became extinguished. Learned Counsel for the second plaintiff, Dr. Emmanuel Safa Abdullah, has submitted in paragraph 27 of the second defendant's case that the moment census results are declared, it extinguishes constituencies. I will not go as far as that, except to state that with a new district block system of representation on the horizon and in place for the next election, it automatically means that the current constituencies will be rendered redundant at the dissolution of the current Parliament, except for calculating the population quota when that time comes after the forthcoming elections by the new Parliament. The effect here is that these current constituencies, for purposes of representation of the people in Parliament, can never be extant and subsisting after the forthcoming dissolution of Parliament and for purposes of the forthcoming elections. Fourth issue, whether the revision of constituencies are provided for in section 38(4) does not necessarily result in the establishment of constituencies stipulated in section 38(1), 2, and 3, but rather the section provides for the period when existing constitutions should be reviewed, which revision may or may not necessarily result in a delimitation of the respective boundaries of existing constituency. Section 38(4) provides as follows. The Electoral Commission shall review the division of Sierra Leone into constituents at intervals of not less than 5 and not more than 7 years, and may alter the constituencies in accordance with the provisions of this section to such an extent as it may consider desirable in the light of the review. There is a proviso which states, quote, that the Commission may at any time carry out such a review and alter the constituencies in accordance with the provisions of this section to such extent as it considers necessary in consequence of any alteration in the number of members of Parliament referred to in paragraph B of subsection 1 of section 74 by reason of the holding of the census of the population of Sierra Leone in pursuant of an act of Parliament, unquote. The revision of constitutions as provided in section 38(4) would definitely result in the establishment of constituencies, even though it is a power given to the Electoral Commission to review and alter, which can be exercised even when there is no consensus. When there is alteration in the population, the proviso to that section 38(4) of the Constitution states that the review is a matter of must and ought to be done without reference to the time, that is, whether within 5 or 7 years period or at any time. Either way, any review by the Electoral Commission pursuant to section 38 of the will most invariably be affecting the number of constituencies subject to parliamentary approval as the last and final hurdle. Issue number 5, whether relying on section 38(a)(1) of the Constitutional Amendment Act number 15 would preclude independent candidates from contesting for Parliament as contemplated in section 77(m) of the Constitution 1991. The plaintiffs have submitted that if section 38(a)(1) is put into operation by applying the district block proportional representation system, there's no way by which independent candidates will be afforded an opportunity to represent people. In the affidavit attached to the plaintiff's originating notice of motion, the first plaintiff deposed at paragraph 10 thereof that, quote, such a system constricts the political space for people minded to contest election as an independent candidate as provided for in section 77(m) of the Constitution, unquote. In their case, too, it is noted that paragraphs 23 and 24 respectively provides as follows. Quote, it is further submitted for the plaintiff that the use of proportional representation for public elections would negate the possibility of having independent candidates for such elections as is contemplated in section 77(m) of the Constitution, which relates to the loss of an elected independent seat on cross-carpeting to a political party. 24. Moreover, it is the case for the plaintiffs that the proportional representation system gives primacy to a political parties list submitted to the Electoral Commission to the exclusion of the constitutional entitlement of every Sierra Leonean subject to the requirement listed in section 75 of the Constitution 1991 to be entitled to to be eligible as a candidate for parliament. The response by the other side, both defendants, is that the plaintiffs, being both members of the APC party, are not independent candidates and consequently do not have the locus standi to institute this action. They rely on the case of Hinga Norman against Dr. Sama Bani and others, SC 205 unreported. According to the editors of Constitutional Law of South Africa, Chapter 8, page 83 thereof, quote, the concept of locus standi is concerned with whether a person who approaches the court is the proper party to present the matter in issue to the court for adjudication. The word, quote, standing has been referred to as a metaphor used to designate a proper party to an action, to a court action. An inquiry into standing should thus focus on the party who brings the matter before the court, not on the issue to be adjudicated, unquote. In his book, Civil Procedure in Nigeria, 2nd edition, at page 32, under the rubric, has the person intending to sue the locus standi, Fidelis Nwandialo, had this to say, quote, the term locus standi denotes legal capacity to institute legal proceedings in a court of law and is used interchangeably with terms like standing or title to sue. It has also been defined as the right of a party to appear and be heard on the question before any court or tribunal. It is the right or competence to institute proceedings in a court for redress or assertion of a right enforceable in court, unquote. In the case of Samuel Hinga Norman against Dr. Sama Bani and others, unreported, quoted by the defendant's solicitors and counsel, lack of locus standi was used by the Supreme Court to throw out the third and fifth reliefs in the originating notice of motion of the plaintiff. Relying on the Nigerian Supreme Court decision of Senator Abraham Adesanya and the President of the Republic of Nigeria, 1981, all Nigerian law reports 1, the Supreme Court used the strict meaning instead of the modern and liberal approach to throw the matter out of court. In that case, action was brought by the appellant challenging the constitutional validity of an appointment made by the President of Nigeria. The action was dismissed by the Nigerian Supreme Court on the sole ground that the appellant had no locus standi to bring the action as there were no rights, peculiar or personal to him, which had been infringed. The court did not even go into the merits of the case, and issues of locus standi was taken in limine. In Jameh against Attorney General Bandul Civil Suit number 4-2001, the Supreme Court of the Gambia did the opposite, where it held that the plaintiff, being a citizen suing in the Supreme Court alleging contravention of the 1997 Constitution, need not prove particular interest in alleging contravention of the Constitution, and that a citizen is entitled under Section 5(1)(a) and (b) to challenge contravention of the Constitution. In that case, the dictum of Jallo JSC in United Democratic number 1 against Attorney General number 1, 1997 to 201, Gambia Report 789 at 803 was applied as follows, quote, every citizen of the Gambia is competent, subject only to express restrictions and limitations, to seek redress in the court against alleged violation of the constitutional order. That competence vested in the general citizenry is not diminished by one's status as a legislator. The situation might have been different if the plaintiff had voted in favor of the measure, for he cannot then be allowed to mount a legal challenge to what he has expressly supported and approved as a legislator. The plaintiff as a citizen did not need to demonstrate any particular interest in order to vest him with locus standi to bring the instant action alleging contravention of the 1997 Constitution, unquote. In the course of that judgment, Wale JSC said this: a transgression or violation of the Constitution by the government is a wrong committed against the whole country and its citizens. Even the Supreme Court of the United States is noticed now to be shifting from the strict adherence to the locus standi rule to the liberal emphasis of the court's function as a protector of public interest in the enforcement of constitutional limitation, and will no longer be deterred by the mere play of locus standi from concealing a challenge to violation or transgression of Constitution. This court is inclined to follow the modern liberal approach, despite the strict adherence which has been upheld by this court in the Hinga Norman's case. As a matter of judicial precedent, the Supreme Court of Sierra Leone, under Section 122 sub 2 of the Constitution, while treating its own decision as normally binding, may depart from a previous decision when it appears right to do so. We hold that the Member of Parliament is a citizen of the country, without which he would not be a Member of Parliament, and this is a matter of public interest in the enforcement of the Constitution. That apart, it is noted that our Parliament, by enacting the provisions contained in Section 127 of the 1991 Constitution, made it possible for the first time for a private litigant, a person, to institute proceedings to challenge the constitutional validity of any enactment, as well as to challenge the validity of anything done under the authority of the 1991 Constitution or any law, without requirement that the person should show that he has a legal right or interest, personal or peculiar to him, which has been adversely affected by the act or omission which he seeks to challenge. This accords with is in tandem with those provisions. Having said that, it behoves me to go into the merits without striking the relief out as would have been if I uphold the local standard arguing. In this regard, the defendant's solicitors went further as to argue that the claim is a mere speculation. This being the case, we do agree that such consideration that independent candidate will be unable to take part was only speculative, as in the statutory instrument number 13 of 2022, now in force dated 16th November, there is ample provision for independent candidates to contest the election. They will nonetheless be representing a whole district instead of just a constituency, and the percentage of votes he or she secures is what will make him or her to be seated in Parliament. As long as an independent candidate fulfills the requirement as detailed in Section 75 of the in terms of qualification, fulfills the requirement for nomination wherein he is nominated in writing by 3 voters from the electoral area where he or she intends to contest the elections, see Section 10 of SI number 13 and Section 58 of the Public Elections Act number 17 of 2022, and complies with other regulations as detailed in Section 72 of SI number 13, dealing with apportioning of seats to political parties and independent candidates, which provides as follows, quote, where the valid votes cast for an independent candidate results in that candidate winning more than one seat, the extra seat or seats shall be assigned in accordance with the highest remainder formula for apportioning seats to political parties or independent candidates, unquote. He or she is entitled to stand, contest, and can win the seat in the proportional representation district block system. Sixth issue, whether Section 2 of the statutory instrument number 13, dated 16th November 2022, making provision for both representation for both members of Parliament and local councils, is ultra vires Section 33 and 38 of the Constitution Act number 6 of 1991. The Plaintiff's Counsel, in his statement of case, has made a heavy weather of the unconstitutionality of the regulations, noting that it is primary legislation that can determine the form of the legislation and not subsidiary or secondary legislation. The Plaintiff's Counsel, in his statement of case, has made a heavy web of the unconstitutionality of the regulations, noting that it is primary legislation that can determine the form of the legislation and not subsidiary or secondary legislation. The power given to the Electoral Commission under Section 33 of the Constitution Act number 6 of 1991 and Section 171 of the Public Election is to conduct and supervise elections are not to determine the form or mode of elections. He stated categorically. He concluded by stating that because of this, what the Electoral Commission, the second respondent, did by regulations titled SI 13 and 14, published 16 November 2022, was in excess of the Electoral Commission's powers and accordingly ultra-vires. He went to state further that they did not even give any explanation for what they did. Firstly, this argument cannot be supported in view of the fact that it was primary legislation that brought the amendment to the Constitution Act number 6 of 1991 in the form of Constitutional Amendment number 15 of 2001 into force. This was clearly the work of Parliament in the primary legislation titled Act number 15 of 2001 as opposed to a subsidiary or secondary legislation. And government after government have remained steadfast with the provision, not choosing to abandon it, but to keep it within our laws. Secondly, and most importantly, it would appear the Learned Council has downgraded the effect of regulations as laws of the country. Under Section 171C of the Constitution of Sierra Leone, it is stated that the laws of the country shall comprise inter alia, quote, any orders, rules, regulations, and other statutory instruments made by any person or authority pursuant to power conferred on that behalf by this Constitution or any other law, unquote. It is clear to me that those regulations are laws of Sierra Leone made by or through the contribution of Parliament, as they are laid before Parliament and would only become law on the expiry of 21 days after being so laid without objection, unless before the expiration of 21 days Parliament annulled same by 2/3 majority. Yes, they are secondary legislation, but still laws of the country, and a better way to making laws when an emergency and technical expertise is required, except that it must conform to the principal authority, the primary legislation, from where the authority to make the law emanates. Thirdly, Learned Council has categorically stated that using Section 33 of the Constitution Act number 6 to put into operation the district block representation system, those regulations are stated in section in statutory instrument numbers 13 and statutory instrument number 14 of 16 November 2 is in excess of the powers granted by those provisions and accordingly ultra-vires. He relies on Section 124 of the Constitution, which in B part says where any question arises whether an enactment was made in excess of the powers conferred upon Parliament or any other authority, referring to the Electoral Commission or person, Chairman ECSL, by law or under the Constitution, unquote. He states in no uncertain terms that the power given to the Electoral Commission under Section 33 of the Constitution and Section 171 of the Public Elections Act number 17 of 2002 is to conduct and supervise elections and not to determine the form of elections. In order to determine whether such assertion as postulated by Learned Council is correct, Section 33, it is noted, provides as follows. Subject to the provisions of the Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all elections and referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary or local government elections and referenda, and other matters connected therewith, including regulations for voting by proxy, unquote. The question that begs an answer is what is the extent of the Electoral Commission's powers, and whether by this enactment of the regulation via statutory instrument numbers 13 and 14 they exceeded those powers. My task, therefore, is to conduct a judicial review of the Electoral Commission's actions via the creation of statutory instruments number 13 and 14 of 2022 on the one hand. That is, whether there has been a breach of the statutory constitutional requirements by putting it into effect of force, SI numbers 13 and 14 of 16 November 2022. On the other hand, also, noting the Plaintiff's Counsel has made a heavy meal of the fact that the Electoral Commission did not give reasons for the action or simply that the reason given was very lame and weak, one must ask whether in fact they acted reasonably. That is, whether their actions were procedurally regular or winspear unreasonable. See the case of Associated Provincial Picture Houses Limited against Winspear Corporation, 1948, 1 King's Bench 223. See also Regina Gates Hall, University Visitor Ex parte page, 1993 to AC. In the case of Council of Civil Service against Minister of State for Civil Service, popularly referred to as the GCHQ case, 1985 AC 374, the House of Lords stated that the grounds for judicial review may be subsumed under 3 headings. A, illegality, put simply, decisions not within the institution or commission's powers. B, irrationality, attesting to the fact of the decision being unreasonable, and where the Winspear principle becomes relevant. And thirdly, C, procedural impropriety, alluding to the process and whether due process was done or the decision was effected in disregard for the rules of natural justice. The deep clock in the GCHQ case noted that by irrationality, I mean what can be succinctly referred to as the Winspear unreasonableness. It applies to a decision which is so outrageous in its defiance of logic and of accepted moral standards that no reasonable person who has applied his mind to the question to be decided could have arrived at it. Whether a decision falls within this category is a question that judges, by their training and experience, should be well equipped to answer, unquote. Thus, whether or not a decision falls within the ambit of this category is a subjective test and depends on the interpretation of the judges. Judge or judges are hereby set out to conduct the inquiry on these terms. Regarding the first inquiry on the Electoral Commission's powers, these can be gleaned from the Constitution, and these are from Section 33. 1. For the conduct and supervision of all public elections and referenda. 2. For the conduct and supervision of the registration of voters. 3. To carry out 1 and 2 above do have powers to make regulations by statutory instrument for A, the registration of voters, B, the conduct of presidential, parliamentary and local government elections and referenda. 4. To carry out 1 and 2 above to make regulation for matters incidental and connected with presidential, parliamentary and local government, including regulation for voting by proxy. Section 33 starts with subject to this Constitution, unquote. Consequently, there are other functions detailed in this Constitution which are not necessarily stated in Section 33 of the Constitution, and these include A, the Electoral Commission shall review the division of Sierra Leone into constituencies at intervals of not less than 5 and not more than 7 years, and may alter in accordance with the provision of this section to such extent as it may consider in the light of the review. See Section 38(4). See also the proviso to Section 38(4), which states, provided that the Electoral Commission may at any time carry out such a review and alter the Constitution in accordance with the provisions of this to such an extent as is considered necessary in consequence of any alteration in the number of members of Parliament referred to in paragraph B of Section 1 of Section 74 by reason of the holding of the census of population for Sierra Leone in pursuance of an act. It is arguable to state that the Electoral Commission never decided the form the elections would take, in that their duty was only to advise the President and that the decision is his alone. Did the Electoral Commission exceed those powers when it decided what the form of election should be? I think not. The Plaintiff's Counsel has constricted the meaning of control and supervise to what is reflected in Section 68 of the Public Elections Act 2022. That cannot be. Firstly, the meaning of control under Black's Law Dictionary 8th edition is control as a noun to direct the indirect or indirect power to direct the management and policies of a person or entity, whether through ownership, by contract or otherwise, the power or authority to manage, direct or oversee. Control as a verb to exercise power or influence over, to regulate or govern by law, to have a controlling interest. This is quite expansive. Tell me somebody who is in control, who cannot determine the form for what is under his control, the form what is under his control should take. Surely that person is a lame duck. A pastor in charge of a church will tell you this is the form a particular service will take. And it goes on and on. Also, that list in section 68 referred to is not exhaustive, as brought out by section 68.3 of the Public Elections Act 2022, which states, quote, during an election, the arrangement under this section and other enactments relating to the electoral process general and other enactment, emphasis mine. It is but clear to me that the Electoral Commission, second defendant, by making those statutory regulations, never exceeded its authority as given by both section 33 and section 71 of the Public Election Act dealing with their role of function. On the other limb, on the second limb, as to whether the decision taken was unreasonable and the explanation given, which plaintiff's counsel described as weak, it is my view that the decision taken to advise the President was a reasonable one under the circumstances. The second defendant, as we have stated, acted within their remit, the Amendment Act number 15 of 2001. The decision was rational and evidence-based. National census results being the trigger to such development. Also, ECOWAS protocol and the 6-month deadline all being reasons why they had to abandon one system for the other and the law allowing same to happen. Any other decision would have caused delay, which would mean going against the Constitution in terms of postponing the elections, extending the terms of Parliament and the Presidency, delaying the beginning of the terms for the new Parliament and government, breaching ECOWAS protocol on elections, and in fact, committing a worse form of illegality. I therefore hold that the correct and most reasonable decision was taken to advise the President to change the form of elections from a constituency-based election to a district block representation system which is provided for in our laws. The moment the decision was taken, all concerned were informed immediately as reflected in the press statement dated 21st October 2022. As could be seen from paragraphs 38, 39 and 40 of the defendant's case, which I quote with approval, it does not in any way undermine our democracy. Whether the entirety of Section 38A of the Constitutional Amendment of 2001 does not provide nor contemplate local councils elections, and whether the word basis on which local councils were elected is the subsisting and only lawful basis on which any public elections involving local councils can be held, and not the proportional representation system. A close look at Section 38A1 of the Constitutional Act number 15 of 2001 shows that this primary legislation has not made any provision for local councils. Thus, on the face of it, it appears as if there is no provision for proportional representation in local councils elections. However, by the same token, a close look at the principal provisions for election of members of Parliament through a constituency-based system of elections will show also that it only made provision for elections of members of Parliament with no provision for local councils. Section 38(1) of the Constitution of Sierra Leone, Act number 6 of 1991, provides 1. Sierra Leone shall be divided into constituencies for the purpose of electing the members of Parliament referred to in paragraph B of subsection 1 of section 74 of this Constitution, as the Electoral Commission acting with the approval of Parliament signified by resolution of Parliament may prescribe. 2. Every constituency established under this section shall return one member of Parliament. In 208, despite this provision, which was geared towards the election of members of Parliament and members of Parliament alone, because of the provisions of Section 33, which deals with the functions of the Electoral Commission and reads as thus, quote, subject to the provisions of this Constitution, the Electoral Commission shall be responsible for the conduct and supervision of the registration of voters for and of all public elections and referenda, and for that purpose shall have powers to make regulations by statutory instrument for the registration of voters, the conduct of presidential, parliamentary, or local government election and referenda, and other matters connected therewith, including regulation for voting by proxy, unquote. The then Electoral Commission, being faced with a situation having to delimit wards for local council members or councillors, was constrained to put into motion Constitutional Instrument Number 2, published on the 17th of January 2008, titled the Constitution of Sierra Leone Act Number 6, 1991, Wards, Boundaries, Delimitation, Regulations 2008. In that body of legislation, it reads thus: in exercise of the powers conferred by Section 33 of the Constitution 1991, the Electoral Commission makes the following regulations. It is by virtue of these regulations that we now have wards, boundaries delimited for local councils. And this is so despite the seeming restriction of the provision dealing with constituency-based election for MPs and the delineation of boundaries only for that purpose as per Section 38. The form or format of the election was brought about through a subsidiary legislation, and we are unaware that any force was made to this court that a subsidiary legislation was used to effect such change when the guiding provision on constituency-based elections or the main provisions guiding did not even mention wards or appear to have considered local councils. In the case before me, in the one sense as regard ordinary members of Parliament, the form of election has been long determined by Parliament, when as a result of the presence of the conditions being a proportional representation system became necessary as per law established and was approved by the President. With regard to local councils elections, I would say ditto. The same has happened as was the case in 2008. While the constitutional amendment has not said anything about local councils in Section 38A1, in the spirit of that provision, through their functions as provided by Section 33 of the Constitution, the Electoral Commission, whose mandate it is to conduct and supervise any public elections, have sought before Parliament through a subsidiary legislation, to wit, the laying before Parliament and getting its approval after 21 days. To the SI numbers 13 and 14 for a proportional representation system for local councils are approved. Should we now, as a court, reject same? I should think not. The word conduct has been seen above is broad enough as to encompass all of this. Firstly, a precedent has been set, which I dare say is not only consistent with the Constitution because of Section 33, but it's on all fours with what transpired in 2008, leading on to the passing of the Boundaries Wards Delimitation Regulation 2008. Secondly, the Electoral Commission would not be acting outside its functions, which are well stated in Section 33 of the Constitution Act Number 6 of 19, which has been well documented. Thirdly, by Section 32(11) of the Constitution, in exercise of these functions, the Electoral Court is not subject to the control and direction of any person or authority. Declarations. All things considered, this court hereby makes the following declarations. 1. That on a proper construction of Section 38A, 1 of Constitutional Amendment Act Number 15, all conditions precedent for the holding of or conducting of general elections of ordinary members of Parliament to a district block representative were met and or fulfilled. 2. That the directive given by His Excellency the President to the Electoral Commission of Sierra Leone to hold the 2023 elections, public elections for ordinary members of parliament by the district block representation system instead of constituencies was in tandem with the provisions of Section 38(1) of the 1991 Constitution, as amended and therefore not ultra-vires. 3. That the current parliament will soon be dissolved, and thereafter all constituencies currently existing will be extinguished for purposes of representation in parliament in favor of representatives representing each of the 16 districts of Sierra Leone, inclusive of independent candidates who secure the minimum threshold for the attainment or securing of seats in parliament. 4. That the revision of constituents as provided in Section 38(4) does lead to alteration of the number and or establishment of subject to parliamentary approval. 5. That independent candidates can and are part of the electoral system and can stand and be voted for to be included in any of the seats representing the existing 16 districts in the country. 6. That statutory instruments number 13 and 14 of 16th November are part of the laws of Sierra Leone and are not ultra-vires Section 33 and 38 of the Constitution Act number 6 of 1991, Section 38A of the Constitution as amended in 2001, and Section 171 of the Public Elections Act number 17 of 2001. 7. That pursuant to and subject to the current law in the country, inclusive of the Constitution and statutory instruments number 13 and 14 of 16 November 2002, local councils elections will be expected to be by district block representations approved as the mode for the 2023 elections. 8. An order restraining the second defendant, Electoral Commission, its agents, servants, privies, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block representation system is refused. I say that again. An order restraining the second defendant, Electoral Commission, its agents, servants, privies, or howsoever called, from taking steps aimed at conducting the 2023 multi-tier public elections on the district block proportional representation system is refused. Emphasis mine. 9. An order directing the second defendant to hold the June 2023 elections for ordinary members of parliament and council on a constituency or wards basis is refused. Emphasis mine. Cost. On the issue of cost, this court notes that this is a public interest-based litigation and hence is not inclined to award the usual cost. A minimal cost is therefore awarded in the sum of 3,000 millions to be borne by both plaintiffs jointly and severally, payable to the first and second defendants. I agree. What's that? No matter. Well, you all know the correct one. That's it.
Okay.
Would you please sit? Silence in court, please. Yes.
Do I have the Lordship's ear?
Yes.
May I, on behalf of my client, say we note and take under advisement the 53 odd pages that your Lordship has read out this morning. A judgment that is full of promise and pregnant with possibilities. We will accordingly advise them. May I, before I take my seat, commend the court with respect, if you'll allow me, to say we hope in the future administration of justice in this country, the same alacrity that has been displayed by no less than the Supreme Court in listing the case, hearing it, and determining it within 18 days of the conclusions of the arguments and submissions be attended with and paid to future cases in court to ensure the peace, liberty, and tranquility of our republic. Thank you.
My lords, once more, on behalf of myself and the team and the defendant, the first defendant, the Attorney General and Minister of Justice, we appreciate the judgment and we commend your industries in arriving at such a decision. Just a clarification, my lord. I am sometimes confused between the new Leones and the old Leones with respect to the issue of cost, my lord.
New Leones is 3,000.
That is...
Old Leones is 3 million.
3 million.
Yeah.
Thank you, my lord. We just want to bring to the attention of this court that this is the very first time the law office has been so industrious without outsourcing, where billions are paid to counsel. This was done amongst ourselves, the new generation in the law office.
It's the sacrifice you have.
We thought we were going to appreciate the younger ones, not for self but for others. As my lord pleases.
Yeah. You have to make it fast. One of us is traveling today.
Short statement on behalf of the second defendant. I also want to adopt what Dr. Abdullahi Conte said, and I want to commend the court for the swiftness with which this matter has been handled. And I hope that the lower court will be bound by this, not just as advised, you're bound by it, so that the numerous judgments that are awaiting delivery are done. The second defendant, my lord, is very pleased that they can now go ahead with the work of conducting the national elections, which we believe will be free and fair. On behalf of the second defendant, I want to thank you for a very detailed and elaborate judgment, taking into consideration all of the arguments today. Thank you. No, I'm not. We're not part of the 3 million. You can take it. It's 3 million is quite enough. It's quite enough for you guys. Not. Thank you.
Rise the court. Thank you.
Yeah.
The judgment has been reached. The long-awaited judgment has been reached, and the court has dismissed the motion by the plaintiffs for the ECSL not to conduct the elections on a district block system. So, by this judgment today, which is the 9th, we take the 9th of those among the reliefs sought by the plaintiffs would take the 9th by the judges, the Chief Justice, that the elections are going to be conducted as declared initially by the ECSL in consultation with the President. So meaning, by this judgment today, with emphasis, the elections in June, 24th of June precisely, is going to hold and going to be conducted on the district block system. This is what this judgment means now today. And the motion by the plaintiffs that the ECSL lacked the legality to receive advice or to advise the President on declaring the proportional representation or district block system for the conduct of general elections has also been refused by the courts. So this is what the court has done and what many people have been waiting for to determine the outcome so far. So what we saw initially to be a virtually developing full capacity of the court was what we actually saw in the end. The fall was because this courtroom was full to capacity. So it's almost getting empty now because what they were waiting to hear has been heard. So they are leaving now while the judges have made their exits to their chambers. This is what the court currently looks like. And the people who brought the matter before the court are still down there with their legal representatives, but their members and supporters are still within the courtroom. And this is what it means now for the elections in Sierra Leone to be conducted. It goes on 24th June 2023 and on the district block system because according to the judges, it is legal. And the law still exists, even though Parliament had the opportunity to review it. It still exists for the alternative means of either district block system or a constituency basis for elections to be conducted. And even though there is no such provision in the constitution for local councils, but precedents had been set in 2008 for the local council elections. So we have reached the long-awaited verdict or judgment or ruling by the court, which has been handed today. But let me hand you over to Daniel Mosiri for the rest of the commentaries, who will bring you analysis on this day and subsequently on the judgment that has been heard so far. But so far, till we meet some other time, we will get much more reports on this and analysis. My name is Patrick Salia, and the rest of the commentaries here will be handed by Daniel Mosiri.
Thank you very much, Salia. Well, family, I want to make this clear for now. Now they listen and follow live broadcast from the Supreme Court of Sierra Leone. And just want to let you know, now 5 judges now they sit down for this matter. Of course, you get the Honorable Chief Justice, Justice Lordship, Justice Babatunde Edwards, and of course 9 leads the other judges, and then the Honorable Justice N.C. Brown-Mack, we a Supreme Court judge, the Honorable Justice Manga Fana Dintawali, Justice of the Supreme Court, the Honorable Justice Alusan Sise, Justice of the Supreme Court, and the Honorable Justice Ansumana Ivan Sise, Justice of the Appeals Court. Well, now the 5 sit down on this matter. We, of course, the plaintiff, that the one that we bring the case, when Honorable Abdukagbo of constituency 077 and Honorable Councillor Hakiatu Maxwell George Poker. We, of course, now the second plaintiff. Then people in there, then come with this matter, and I go remember that the ECSL being consults, of course, with the consultation of His Excellency, be declare, say the election will go come on the 24th of June 2023, it will be proportional representation. But quickly, I got now, of course, the Solicitor General. We, of course, now of course, the Agbi Kowa. Good morning. Good afternoon, sir.
Good afternoon.
Of course, the matter, well, I'm not going to say long matter, but the Supreme Court's matter, we, of course, have been bringing there, you know, in terms of the proportional representation, and of course, the government side, and the plaintiff them, of course, Honorable Abdul Kagbo, and then let's Hakia to Maxwell Walker. But now today, the judges them, the Supreme Court, don't give a ruling. What does this mean to Sierra Leone?
Well, this means a lot to Sierra Leone. Firstly, we see the kind fastness, the expeditious nature with which the Supreme Court deal with the issue, knowing how elections matter, they may not detain at this court. This one then deal with them fast so that the Electoral Commission will get enough time for go about their on conduct of the elections based on their calendar.
Briefly, let's look at the ruling. You know, don't forget about all that long, you know, constitutional talk. But let's look at briefly the ruling. What did the ruling indicate?
Well, the ruling establish and try for educate and tell we Sierra Leoneans say we get for familiar with the electoral process who gets in this country, and we get for be able for decipher and know which one we get for use at a particular time. Explain and come out with the jurisprudence of the constitutional provisions dealing with elections, and that'll be a very good ruling way everybody, I think, could learn from. All lay people could learn from that.
Now, let's look at few of what's in the Chief Justice say in terms of ruling, because they talk about cost as well. We, of course, it's a minimal cost of 3 million euros. We, of course, the two plaintiffs them for award to the two defendants. How, of course, that money, I mean, it is reasonable, but therefore pay them to so.
Yes, it's a reasonable amount, which to an extent that is a decision of the court. We cannot challenge it, not the Supreme Court, though we been they expect something more. Especially, you go realize that this is not the first time the law officers on its own take up issues like this and deal with them without they not go outside the law office for solicit the services of any other lawyer, which them in the past have been paid millions or whatever. So this time it shows we can do it. It's a new generation in the law officers department, and we are representing the government and all institutions under the government very well. We have younger ones, junior barristers, them where they work there, state council them, where this not just for motivate them. So we've been they expect say further motivation with the industrial work we don't put into this case, they would have been appreciated. However, we're satisfied.
So in conclusion, that the PR system of elections is the goal?
Yes, this is the PR system. That is clear, it's a constitutional provision the Supreme Court has ruled, and that is sacrosanct.
Thank you very much.
Welcome.
Well, of course, I get the other lawyer. We represent the second defendant. We, of course, now Dr. Emmanuel Safar Abdullahi. For welcome you, sir, to SLBC.
Thank you very much, Dan.
All right.
I'm glad to be here.
Thank you. Now, the Supreme Court don't give judgment. I'll look at the judgment, but in actually, how na take up?
Well, we two angles we take on. First, for the last 2-3 years, I mean, political parties, opposition political parties, don't they accuse me for being, you know, less independent and for doing wrong things, for acting illegally. The Supreme Court spent some time to talk about that. That's firstly, all what you don't do in the past, all the steps where my clients don't do, they're doing right, and it's within the law, in the Constitution, and the law allowed them for advise the presidents for conduct election as they want to go. And that as soon as statistics publish the midterm census election, that the need for conduct boundary delimitation to get triggered will become the condition precedent. Then, so everything we did basically was right and illegal. But the second part of it really is we don't get a free hand for do the elections where everybody they look forward to in June. The clients don't get a free hand for do that. Going forward, the Supreme Court be very clear that NEC no more get the right and powers to conduct elections, and then get the right to make regulations and get the right and know the information where they get, where they go advise on the electoral forms, where they were able to carry out. So we were glad that the Supreme Court ruling came out today, and everybody don't see say all waiting people and don't they say about the commission, the electoral commission, not true. Now within the law, the clients and they operate, and this is very good.
Lastly, before we go, of course, the judge been talk about cost. Will satisfy the cost?
No, I mean, you could see what in the judge try to do. I mean, people get rights for challenge actions of public institutions, join Supreme Court. The Supreme Court is not a place where people operate because of cost. So when it's a public interest, it's not a matter where everybody get interested. Everybody they watch on the TV, everybody they listen to waiting the judge, then they say because now they move with democracy. So if the court can put heavy cost, people next time go afraid for come. So you give a cost where not very important, just for say okay you pay a cost, but you encourage people for come more. And I think while we dissatisfied with that because we as an independent body with clients and we don't spend a lot of money in doing this, but at the same time for the betterment of Sierra Leone and Sierra Leone's democracy, I think this is very good.
Thank you very much.
Thank you.
Dr. Safa Abdullahi. All right, okay, well, Fumblem, of course, we go conclude because we don't get from the two defendants' lawyer them. It's unfortunate we're not able to see the plaintiff and lawyer for lawyering from their side, but however, not so the judgment, the ruling being at the Supreme Court, and this could go down in history that let me challenge a system of voting, but the Supreme Court turned and down, and the defendants at the government side, and of course the ECSL, they're able for win the case, and now one for Leone and no say the election that take place on the 24th of June 2023, and we will go with the PI system, whereby the PI system now you will not vote for a candidate, but you vote for a political party. Well, now so we go round up, and one for telling thank you, and to follow the SLBC continue. We go continue for bringing important information.
Does not
Until
matter
then,
at any
thanks
time
to the
than
cameraman
now.
David
When the
Williams,
world
and
has
of course
become a
technical
global
man
village.
Alex Sise, and on behalf of my colleague them,
Now
New
we have
England
to
Vale, and Leicester
communicate
Peak
in
and
a
all,
global voice.
one for wishing
When
a
the
pleasant
local
good
audience
afternoon.
get along.
My name that must
The
say
ability to use the
and
21st
say
century
bye-bye.
media tools as an end user, and also the most sophisticated tools, either online or offline, with professional tutoring at every level. That is what we provide.
One aspect I am grateful for at the Central University Mass Communication Department is the confidence I have in it.
I know my study in the media is top-notch, and I can compete at global levels. At the Central University, there is no dull moment when learning.
The environment is serene and friendly.
The department prepares us for radio, television production and filmmaking. We are also prepared for multimedia content production, marketing and advertising. We are accustomed to different softwares to unearth our ideas and test theories taught in class with different world-class professionals, instructors and mentors.
The real-life experience here at Central University in Sierra Leone.
I am going to be a multimedia content producer and a social media expert.
It has always been my dream to become a communication researcher and a podcaster. And now, my dream feels so real.
I am Judicial, a second-year mass communication student at Central University. I am a reporter and a video editor at Central University Television. Since I came to Central University, my gender has not been a limitation. I work with guys and do what they can do, and even much more better.
Apply today and be part of the Central University family, the epitome of modern education in Sierra Leone. The discipline of mass communication does not matter at any time than now.